He was there earlier in the weekly.
Listed before this one.
You should have come and argued that matter. You didn't come.
For that reason, I'm saying, my lord.
Including the weekly list, let us see.
My lord, item 42 and 107. And so my
Yes,
learned senior is there. It was
Jyoti, wherever Mr. Maharana is appearing, put a tick mark. He has some personal difficulty. Yes.
My lord.
Pardon to myself.
You give your number, Mr. Maharana. Give you go.
107. It is specifically fixed to 2 p.m.
He has.
Yes, I have talked to him. A date may be given.
No, don't worry.
Item 7.
Consult Mr. Mishra.
Item 72, my lord. Not fresh, my lord. In the meantime,
Yes.
present petition is approved.
Not fresh. Yes, it is, huh?
Item 27. Therefore, an additional
Bail matter.
documents appeal, criminal appeal, CRL. 27.
Challenge of 2017. Yeah, it was not last listed on.
It will come. Serially, these matters are coming up. Don't worry. Don't worry, it will come.
Item 79. Prisoner petition আসছি কিন্তু ଆମେ power file କରିଥିଲୁ କିନ୍ତୁ ଆସିନି
Bail matter.
bail matter.
Urgent court.
Pardon to mention, my lord, item 74, my lord. Permit to withdraw, my lord.
74 withdrawn.
93 and 101, my lord. Can be taken to its after.
Matters. All bail matters.
93 bail item and 116 CRL, my lord.
Bail. So bail to call. CRLMC will see. Bail urgent. CRLMC will see. Yes.
And no.
Lord, I may
We'll
be.
see CRLMC. Unnecessary pending, then I'll have to take a call. Bail you don't want. Let it be. Yes.
Lord, item 128.
Acha. 128.
8.
Yes.
It's a hearing matter. Can I pray the may be taken up?
That is weekly.
128
Weekly. Let it be there, Mr. Behra. How does it make? Weekly list will see.
No,
When
only-
it reaches, I'll accommodate.
My only prayer is let it be taken up Friday at 2 p.m. so that it will take maximum 5 minutes. Only one
Thank
point
you.
is there.
Thank you very much. You have not said Sunday. You have fixed the time. You have fixed the date. You have to see the convenience
Yeah,
of the court also.
or as per your lordship's convenience.
Let it be there. Let it be there. Whenever it reaches, I'll accommodate you. Don't worry about it. Don't worry
Okay.
about it.
Okay.
Pardon, my lord.
Item number 20.
Yes.
A matter was listed on 8th August 2024 and the order has been passed by this lordship. The matter will be taken up within 2 weeks. But the order uploaded is the matter will be taken up on 20th September. That is for after 6 weeks. So
Which one, ma'am?
1911 of 2024.
You give the number. You're not. We are not able to hear you properly.
BLAPL number 1911 of 2024.
Oh, 19 BLAP number 1915.
11.
19.
1911.
Okay, I just check it up. Huh? Check it up.
1911.
Check it up and.
I may be pardoned, my lord. I may be pardoned to make a mention, my lord.
Yes.
My lord, item number 45, due to some personal difficulty, my lord, I am unable to address your lordships today. If your lordship kindly accommodate me for a day, it can be addressed, my lord.
35.
45. 45.
45. Okay.
My lord, item number 28, my lord.
Much obliged.
Yes.
My lord, item number 28 can be taken up after lunch.
Oh, I'll pass it over. Don't worry. You need not request that. Yes.
Pardon to make a mention, lordship. Item 30. on
That
the-
30.
Yes, your lord.
Yes.
Kindly be taken up on next week to Wednesday, 21st.
No, you can't fix the date. Well, we will fix
Next
the
week,
date.
any date, lordship?
We'll see. Weekly. Let it be there in weekly. Yes.
135, your lordship.
135 also. Weekly list. Let it remain. How does it make it? Why you're mentioning? May reach, may not reach. Yes.
Pardon to mention an item out of the list.
Item 30, due to non-appearance, it was listed today. We are, status report has been sought. So let's say
We'll see, status report hasn't come today, it seems.
we are appearing in.
Appearance.
Pardon to make a mention, Your Lordship. One matter posted to 27/6/2024, but not listed after several requests. May kindly taken up. Stay was there, Your
What
Lordship.
was
This is a question 482 matter.
482?
Yes.
Which year?
2023,
Give it to, we'll see.
2023, two
Yes.
matters. Your
My lords,
Lordship.
pardon to mention an item out of the list. My lords, criminal appeal number 235 of 2006. My lords, may kindly be taken up tomorrow.
Which item?
My
Why
lords, it's-
tomorrow? I don't know.
My lords, it's out of the list.
Out of the list, I'll take tomorrow.
Does it-
Whichever is there in the list, you know, you don't come.
My lords, it was earlier listed in the weekly list.
What is this
My lords,
matter?
appeal matter 2000, appeal matter 2006.
2006. Then nobody appears then, urgent. What is this matter is about?
My lords, under Prevention and Corruption Act.
I know that appeal means prevention of corruption. What is the
My lords, earlier we had mentioned last date also on Friday.
link include kar do yaar, please. When the matters are there, you people ask for time. When I have no time to hear, you want to get it included. It makes no sense. Yes,
Similar matter, my lords, on the PC.
give it to it.
CRLMC
It will be included.
Please, your lordship.
Include all these appeals in the.
Similar,
CRLMC serially.
my lord, similar matter already disposed of.
We'll see. Yes.
My lord, in item number 5, the petitioner was transferred the petition file to another advocate and engage a senior advocate, and so
Good, then let the senior advocate come, we'll see. Huh? Yes, next. Call.
Item,
Call.
my lord, 113, my lord.
Hmm?
Item 113, my lord.
This may not reach weight. Yes. Call. 42. Yes, what is this matter? Marana. Urgent. Yes. 43.
Item number 43, your lordship. My, in this matter, the senior advocate, Mr. Dharandar Naik, will appear, and I pray you take up the matter day after tomorrow, because today he is outside the state.
Sir,
They-
I tell you one thing, this is a wrong practice to tell that you will decide the date and the court has to take it.
My lord,
This is a
I-
very wrong
I
way of
cannot say.
approaching.
I'm sorry, my lord, I cannot say because he
You
is
fix the
not
date,
available.
you fix the time without realizing that the court has lot of matters. Court is not dealing with only your matter. Every day hundreds and hundreds matters are there. You can't fix your date, you can't fix your time.
Nah,
Try to
no.
appreciate that. You
No,
see
we
it as
cannot, we
adjournment,
cannot.
it's all right. It will be urgent, but it will be urgent, and whatever the board permits, accordingly it will be listed.
Because he is not available,
Maybe
to not
because
available to today.
for every adjournment there is a because.
On my mention,
We are not interested because.
on my mention, this matter is listed. But unfortunately, because of his
I am accommodating you, no, but it will be listed according to the wherever the board permits. That's the problem.
maybe any-
Once you mention it is listed, and again you ask for time.
I should not have.
The
I
board is
should-
completely disturbed.
No, I should not have, because I am feeling very sorry because of this sudden problem, because of.
Anyway, I am accommodating your request. I am accepting your request.
I'm grateful, Lordship.
Urgent. Okay.
May I please.
Yes, sir.
Challenge is to order passed by the learned magistrate refusing 205 application.
205.
Yes.
This is the 2CC case.
2CC case. Milords, the late husband of the petitioner and the petitioner. Milords, late husband of the petitioner was the managing director and the present petitioner is the director for the namesake, Milords,
Yes.
of a pharmaceutical company.
What are the offenses?
27D of Drugs and Cosmetics Act. Lords, they are resident of Lucknow. Lords, the proceeding has been initiated in the district of Ganjam in Kodala. Lords.
This is, she is a lady.
Mal.
What is husband?
Husband has
He is appearing.
No, he has expired in the meantime.
She is the only accused.
She is the only accused, and she is the director for the namesake. Lords, I am relying a decision of this honorable court, the coordinates bench, exactly on similar point, Lords, regarding distance.
Yes.
Lords, there the petitioners were in the reported decision. The petitioners were the resident of Nabarangpur, and the proceeding has been initiated at Barampur. Your Lordship may kindly see paragraph 4 and 6 of that judgment. And I'm resident of Lucknow. Proceeding has been initiated in the district of Ganjam.
So what does it say ultimately?
Ultimately, proceeding 205 application has been allowed. Para 4 is the contention raised by the learned advocate appearing in that case.
You appear in a video conferencing mode.
That's the problem. Is the coordination is required.
You can't avoid that. You appear
whenever necessary.
As and when required, you will appear in person, and the rest of the day you will appear in video conferencing mode.
Coordination is required. She is ailing.
That's right, but see, this is in the court, Barampur court. All video conferencing facilities there. Sit in your house and appear.
Kodala, the coordination from the council is required.
Those things has to be done because on the video conferencing days, and you need not come physically. As and when required, you can come in physically, and rest of the day you can ask the court to appear before through VC,
and
that suffices. Your idea is the trial should go on. That's all.
Yes.
And he will appear. She will appear.
If it is barely necessary, then
yes, I'll say that.
Then trial
Yes. Petitioner is agreed by the order dated 18/8/2023, passed by JMFC Kodala in 2CC case number 1/2009, initiated against her for alleged offence under section
27D.
27D of
drugs and cosmetic scent.
Drugs and cosmetic. The petitioner and her husband.
Cognizance has been taken under that.
Whatever. The petitioner and her husband. Or the petitioner and husband along with the company in which they were director has been prosecuted in the present case. The husband of the petitioner. Therefore, the petitioner is in the capacity of a director and representing the company, namely Malachite Gold Laboratory Private Limited, has been facing the trial.
Your Lordship says is the resident of
the trial at where?
Kodala. Resident of Lucknow.
Facing the trial before JMFC Kodala Ganjam.
She is a resident of Lucknow. That
I know. He moved case under section 205 CRPC, seeking exemption for personal appearance on the ground that she is a resident of Lucknow and is a lady. It's difficult to undertake the journey to appear before the court on each date of hearing. However, the trial court provided impugn order dated 18/8/2023 rejected the application. Hence, she is agreed and approved this court. Pradhan, the counsel for the petitioner, has relied upon a judgment of this court passed in CRLMC 1718/2021, Sachidanand Chaudhary versus State of Orissa. In that case, this court has allowed the exemption application for the petitioner who was the resident of Nabarangpur and was facing a trial at Barampur only on the ground that there is a distance and he cannot travel. And the counsel submits that his case is far better than the case he has cited before this court. Therefore, the petitioner, being a lady residing in Lucknow, is entitled to the relief under section 205 CRP. I peruse the records and the judgment cited at the bar. It is true that the appearance of an accused in a criminal prosecution is a rule and exemption is an exception. Exemption is an exception. But taking into consideration the fact that the petitioner is a lady and residing in Lucknow, whereas the trial is proceeding at Podola, Ganja, she is entitled to the relief sought by her. Accordingly, I allow the prayer of the petitioner, subject to condition that the petitioner shall appear before the court through video conferencing mode, and as and when it is essential for her physical presence in the court, she needs to appear before the court. If exigency arises, she can also move an application under section 317 of everything I have given. All the options are out.
Deeply.
Okay. With this observation, the petition is disclosed. Yes.
47.
Yes, sir.
May I please lordship? My petitioner is in custody.
No, wait.
22/4/2000.
Yes.
22/4/2023.
23.
Yes, lordship.
What is the offense?
Offense under section 20B.
Recovery?
Recovery, my lord, 76 kg.
Yes, sir.
No criminal antecedent. Final peer.
Madam.
No criminal antecedent. Final peer has
Investigation completed that CA of the report of the petitioner not yet been received from West Bengal, madam.
no CMI.
He is driving the car, madam.
More than 1 year.
Yes, lord.
More than one.
Final peer has already been submitted.
76.
Subject to verification of that.
Yes, lord.
Custody in custody since 24/4/2023. Charge sheet filed on
Charge sheet filed on 8/8/2023.
8/8/2023.
Yes, lord.
Chemical examination report is still awaited, which has not yet been made form part of the charge sheet.
Final peer.
Final charge sheet. Then ये कर दो वेस्ट बंगाल है ना प्ले इंचन ऑफ ठीक है
Deep blue.
48 yes recovery 46 76 yes 48 no pass out. What are the offense?
Well, 302 and 201. 302 and 201, I guess, madam.
None appears for the prisoner in the interest of justice held in September 49. September last year. Yes. What is the offense, sir?
Oh, my lord, that offense, my lord. My lord. There's a 147, 148, 121, 121A, and 431, 149, 25 arms at once. And the antecedents are the 4 numbers of criminal antecedents are the petitioner, the Maoist leader, and who
Maoist
leader, madam.
Maoist.
Who always
Naxalite.
my lord.
Oh, adjourn karo. September. Yes.
May I please? But the petitioner is in custody since 22/3/2023, my lord. The alleged offense under section 498A, 506, 306 of the IPC and 4 of the DP Act, my lord.
Yes.
And after 7 years of the marriage, my lord, she has
306.
she has committed suicide.
How she died?
Poisoning, my lord.
Poisoning. You are in custody since?
Since, my lord, 22/3/2023.
22/3/2023,
2023, my lord.
23 1 year old. And your husband?
I am the husband.
Poisoning, just
Poison.
show me that part. Poisoning, how she has taken herself poisoning, or this man has administered poison?
Rejection shows that some material witnesses have already been examined by now.
No, that's right. But poisoning has been, she has taken herself
She has
poison,
for that is my
or
306
you
is
have
charge sheet.
administered.
For that is my lordship charge sheeted under section 306.
I know, but you have administered, allegation is, you have forcefully, read that part.
ମାତ୍ର ମୋର ଝିଅ କୁମାରୀ 22/3/2023 ସମୟ ସନ୍ଧ୍ୟା 5 ଘଣ୍ଟା
Trial is going on. Material witnesses have already been examined. But you have to appear in the court. Otherwise,
I will appear. One default your lordship.
Default recall. ठीक है, वो लिख देना. Additional condition लिखिए. Additional condition, the petitioner shall appear before the court without the fail on every day. He shall not influence the cases. If the petitioner is found violating any of the condition, even for a single occasion, it entails the cancellation of the obligation. Yes. 51. Yes. Offense?
My lord. That offense, my lord. That charge sheeted, my lord, under section 420, 406, 294, 506, 30.
Pass over. 420. 52.
Here, the last occasion, lordship directed to take instruction whether the victim and informant were examined or not, as per the order dated 22/4/2024, on which court has directed he take instruction whether the victim, my lord, I have received instruction, but the IO think that whether they were 161 statement was recorded, he has sent that instruction. So today I have told that IAC who you take instruction whether they are examined before the court or not. So he has sent one
examined, he is not able to understand. Examine means obviously before court.
My lord,
not
but
161.
But he has sent 161.
Day after.
Your lordship, may I pray, your lordship? I have instructions to that effect. There have been bailable warrants that have been issued against that victim. If your lordships looks into the order dated 22/4/2024 of this honorable court, it is
from his mouth I want to
Yes,
hear
your
so that I can allow the
yes, your lordship. On 9th of this month also, the case was posted, and none of them turned up, your lordship.
Okay, you put it in Friday.
Friday.
Friday,
My
let
lord,
him
sir.
know. I want to get from his mouth because he's the prosecutor.
My lord, sir, I'm appearing on behalf of the informant, my lord.
Yes.
My lord, sir.
Which one?
My lord, item 52, my lord. Yes, my lord.
You are not appearing before court.
Sorry, due to, sir, my lord, personal
Why are
events,
you
I
not
couldn't-
appearing before the trial court for examination?
My lord, today
Bailable warrant
the
has
date
been
was
issued against you.
Yes, my lord. Today is the date to my lord. I mean the date of examination of the victim. Last week, her father was examined. Today, the date is maybe most probably around 1 o'clock or 2 o'clock. She will be examined.
Okay,
Your lordship may keep it to
I'm
next
listing
week.
it Friday, and if she will not cooperate with the trial, I am granting bail.
Your lordship.
Friday. Yes. 53. Yes. Yes, madam.
My pleasure, lordship.
Offense.
My lord, in 302 and my lord 420.
Custody.
My lord, there is so many accused persons there.
Sub items are there, my lord.
So many sub items.
Yes.
My lord.
How many? How many of you?
There are, my lord, accused.
What is the stage? All of them want to come out. What is the stage of trial? Do you have? What is the stage of the trial?
So it started for my instructions, but there is no clarity.
Yes, sir. Do you have? No, my lord, I will take instruction regarding the status.
Oh, because all the 302 case, all the accused have come separately.
Yes, my lord. So many accused.
The
allegation
take
will
instruction regarding the stage of the trial in the instant case. release the matter next week. Yes.
54.
40? 54, yes.
Yes, Lordship. I am appearing for the side of Tushar Kapoor, Your Honor, and praying for an adjournment, Your Honor.
Adjourn. Yes.
55.
Yes. Non-appeals for the petitioner last time.
57.
What is the offense?
Charge sheet submitted 498-306 IPC, my lord.
Charge sheet, when charge sheet submitted?
Charge sheet submitted, my lord. On dated. My lord. On dated 13/12/23, my lord.
23.
My lord.
And thereafter what happened? What did this say?
My lord, that some relevant portion of the charge sheet, my lord, I'm reading.
No. What is the stage?
Yes, my lord, that is to be obtained, my lord. Purpose of the trial.
Offenses?
Offenses, my lord, charge sheet submitted 498-306, my lord.
306, huh?
My lord.
Non-appeals petitioner. On the last date of hearing also non-appeal for the petition. In the interest of justice, one more opportunity is granted. List the matter day after. We'll dismiss it. If nobody appears, dismiss it. Okay. Yes.
56.
May I please, Your Lordship? Here the petitioner before my lord is in custody since 14th of 9, 2022. 14/9/2022.
22.
My lord.
Offense?
For being charge sheeted for the offenses under section 302, 201, 120 of
Yes,
IPC, Your Lordship.
302. Yes.
My lord, the case of the prosecution as alleged is that on the alleged date.
How many accused are there?
My lord, in fact, FIR was against unknown persons, but 9 accused persons have been charge sheeted, my lord.
Yes.
My lord,
What are the allegations against you?
my lord, in fact, if the entire case of the prosecution will be accepted as it is, I am not named in the FIR. Absolutely no.
Forget about FIR. What?
Absolutely,
After charge sheet is filed, now tell me.
my lord, absolutely no eyewitness are there to the occurrence, my lord. And I implicated solely on basis of confessional statement of one of the co-accused, namely Pratap Sunna. And that apart, my lord, if the entire case of the prosecution will be considered, last seen theory, neither leading to discovery of the dead body.
Yes, except confessional statement of co-accused, what are there?
My lord, also case there is not there, my lord.
A call for case.
No, my lord, maybe in the next item, the case diary was lastly available, my
Which
lord.
one?
56 and 57 both are connected
Yes,
matters.
57 you have.
My lord.
Is there? What are the allegations against this?
In 57, CD available.
You tell me what are the allegations?
Yes.
57. You are appearing for 57 also?
57 first item I am appearing. Sub item some other advocate is appearing, my lord. In 57 two items are there.
56
56 personal fact.
Honest, alias Brothers bag, 56.
Yes.
Milord. Case is like this, Milord. A dead body was found, but concealed inside the Milord. That was on the behest of one co-accused, Milord. He has told Milord, 3-4 days prior to that, we have disposed the dead body. We have killed that and concealed inside the act, Milord. Then
one co-accused said.
One co-accused said.
Who is that? Who is he?
Pratap Sunna.
Pratap Sunna. Okay.
Yes. Yes, Milord. Subsequently, what happened, Milord? One statement of the one eyewitness. Page 41.
Eyewitness?
Yes. 41. His Brundavana Sunna, Milord. He has categorically stated, Milord, petitioner, all the petitioners, Milord. Take last को टेकी करी नौथिले स्मॉल एंड आज 27 मो एकी जे गत 4/9/2022 तारिख 2:30 भितर आमर पडार थिया भंगा गोदाम घर के छाड़ा जाइथिले गोदाम घर भितर कुआरे पानी छिंगला देखिली सेटिंग बेल देखिली आमर पडार हितेश गण प्रताप विशाल ऑल थ्री मिनट जितु ताभल पडार लास्ट के ଟେକି ଟେକି କରି ନେଉଥିଲେ ଗୋଲୁର ଲାଷ୍ଟରୁ ରକ୍ତ ଜୁଡୁବୁଡୁ ହଉଥିଲା ମୁଁ ଦେଖି ପଳେଇ ଆସିଲି
This witness has already been examined.
No, no, my lord.
This witness ବୃନ୍ଦାବନ ସୁନା
May I pray?
No, let this witness.
No, no, my lord. May I pray one thing only? So far as footing is concerned of both the petitioners in different items, I do admit with all fairness, my lord. So far as the petitioner in 56 item is concerned, absolutely no materials. Even if my learned senior is pressing the
No, all of you have done together.
No, my lord. He has not uttered my name. He is not.
Cannot be, but see, leaving one person in such a situation is so dangerous to influence that witness.
He specifically named 4 to 5 accused persons, but I am not there. 57 item re jo petitioner achi, he has named him. Fairly, I am submitting, my lord.
57. So where is the CD? This case is petitioners are accused. All the matters petitioners are accused. The present case is primarily based on circumstantial evidence, and however, one of the witness, namely
Brindavan Suna, another minute, Ajay Sahu. That
Brindavan Suna, two witnesses, Brindavan Suna and Ajay Sahu, have seen the petitioners disposing of the dead body, and these two witnesses are material witnesses. Unless these witnesses are examined, the petitioner cannot be released on bail at this stage. Therefore, the present petitions are dismissed. At this stage, I am not inclined to enlarge this petitioner on bail. However, the petitioners are given liberty to do their bail application after the examination of the.
And Millard, yes, Millard, 34 injuries, Millard.
Yes, material witness.
Yes, but my lord,
very brutally killed person.
I do admit, my lord, but so far as 57 petitioner in 57 is concerned, absolutely not even a witness.
No, you
uttered his word, my lord.
brutally killed someone. What is? Let these material witness be examined. You can't take it like that. Yes. All the three. Yes.
Pardon, my lord. Item 49 Passover. Urgent.
We'll see. Passover or urgent? Urgent. Nobody.
Pardon,
my lord. Next. 58.
Pardon, my lord.
Yes.
Pardon, my lord. 51 item may kindly urgent to 1 week after.
51 क्या हुआ? Why you people are coming at any time at your pleasure?
No, my lord. Lift पूरा जाम चला मुझे दौड़ कैसे?
Passover, it is Passover. Wait. This is very bad in between interjecting the court proceedings. Yes.
My 58, my lord.
Yes.
The petitioner in this case, your lordship has been in custody 6/1/2022. 6/1/2022.
22. Yes.
For commission of offence under section 376 and allied offences, your lordship. The
164. Read 164.
My lord, in this case, the victim has already been examined. I have annexed that.
Where is
at
that?
page 46, my lord.
Page 46.
46, my lord.
Read it out.
My lord, the informant is my mother. I am the victim in this case. I know the accused Pradeep Naik, who is now present in the dock, your lordship. The occurrence took place near about 1 year and 4 months back, one day at 6 a.m. while I was staying with the accused and his wife and children, a rented house at Khariguda. I was staying in my maternal uncle's house at Kamapada. During my stay one day, I was suffering from abdominal pain, for which the accused took me to the nearby dispensary for treatment, your lordship. Kindly mark. Thereafter, I accompanied the accused along with the wife and the children to his rented house at Hariguda. My lord, at the relevant date and time while I was sleeping in the rented house of the accused at Hariguda, my father and the younger brother came there and rescued me from the clutches of the accused. But I was medically examined in this case. But the medical examination is completely silent about that. During the investigation, police seized my wearing apparels on my production. In the
allegation of rape.
There is nothing.
Yes, my lord. Cross examination, my lord.
Oh, cheap.
Hostile.
6/1/2022. The victim in the present case has already been examined as PW2, who has regaled out of court statement. Relevant would be to reproduce the part of examination chief 46. Examination chief of the paragraph 46 page 46. What is the stage?
My lord, the trial is in progress, my lord.
Trial in progress. The evidence of the victim is also stands corroborated with the evidence of the doctor. Evidence of the doctor who is doctor also said no. The
medical examination report is silent, my lord. I have a next
doctor, because the medical examination report stated to be silent for sexual assault. Taking into consideration the aforementioned, and that the petition is in custody from 6/1/2022, trial in progress is enlarged on bail, subject to this condition. You have to appear single default in appeal.
Single
appeal. Additional condition, 2 additional conditions. You are single is found violation the condition in a single occasion also. It will call.
Well, I am obliged.
Yes. Yes.
Pardon, my lord. Pardon, my lord. Pardon. Pardon, my lord. 57 item. Pass over.
50?
57, my lord.
What?
57.
Now it's 59 is going on. Wait. Yes.
Madam, the petitioner is in custody since 30/10/2023. 30/10/2023.
23. Yes.
And 95 gram of brown sugar has been seized from him.
Yes,
3 number
brown
floor.
sugar.
3 number floor it is police. That is there, madam. 2 criminal answers are there.
So what will you do? 37 straight away.
My lord.
Straight away 37.
My lord, one criminal antecedent is with regard to 47A Bihar Odisha. That is a year-old case in the year 2012. And another case, my lord, this honorable court has granted bail to the petitioner. It is also below commercial quantity, my lord. And my lord, the petitioners.
Show me that.
And petitioner's father, my lord.
Show me that order. Bail order. Next week, huh? Please it.
I guess the Bappa again.
No. Don't. You file all the papers so that the easy ho jaye.
Bappa ta mortgage not.
When?
No, it is certificate done. आज याला 12-3 दिन हला गोटे पुआ है घरे तो कर्म करियो कि ना
वेरीफाई टुमारो
मिलट
टुमारो गिव इट वेरीफाइड
टुमारो में बेल ऑर्डर नहीं आस्ती जो आरो केस रे बेल
ऑर्डर इफ यू आर एंटाइटल्ड फॉर रेगुलर बेल आई विल गिव अदरवाइज इंटरिम बेल आई एम ग्रांटिंग जस्ट वेरीफाइड फादर वेरीफाइड ओके टुमारो
अदरवाइज विल लॉर्डशिप में डायरेक्ट सब्जेक्ट टू वेरिफिकेशन ही विल सेटा आगे सब्जेक्ट टू वेरिफिकेशन
कर्म खाता में यू
आपण एठी का पीएस आगे
आप वेरीफाई करंतु काली लेट अस लीव हिम फॉर सम टाइम फादर एक्सपायर्ड हो यार
आगे
तापर देखियो फाइनल दबाग नहीं देखा जाएगा ठीक है टुमारो 60
maybe you'll see. The present petition on initially corresponds in 10/1/2024.
10/1/2024
for the commission of offense on 376(2) and 506 IPC, my lord.
For there?
Yes, no postpone, my lord. Develop there.
Read 164.
164 and 161, corroborated with 164, my lord. They develop their relationship with the Facebook, my lord.
Just see 164 reading.
Lord, 161 is available.
164 not there. You do have 164.
No, my lord. दौनादी तळकुटरे सर्टिफिकेट को भी दौनादी
आपण सीडी मागो
मगा हेतला शुक्रवार मगा हेतला शुक्रवार मागितलं
Monday.
Monday.
61. 164. Just read it out so that.
Miller.
Yes. Next. Yes, sir.
61, my lord. The petitioner is in custody since 18/12/2023.
18/12/23. Okay.
Yes, my lord. Initially, the FIR was lodged under section 498 capital A, 302, 304B, 34 IPC. Subsequently, the charge sheet is filed.
306.
Yes, my lord.
Yes.
My lord.
How the deceased died?
Hanging, my lord.
Hanging. Bolted from inside?
My lord, that is an under constructed house, my lord.
Yes, sir. Husband, you are husband?
Yes, my lord, I'm husband.
As it appears, my lord, statement of the complainant, he has categorically stated ମୋ ଝିଅର ସ୍ୱାମୀ ବେଣୁଧର ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ପ୍ରାୟ ବହୁତ ସମୟ ମଦ୍ୟପାନ କରି ମୋ ଝିଅକୁ ଯୌତୁକ ଦାବି କରି ବାଡ଼ାବାଡ଼ି କରେ। ଏ ବିଷୟରେ ମୋ ଝିଅ ଫୋନ ମଧ୍ୟରେ ମୋ ପାଖକୁ କାନ୍ଦି କାନ୍ଦି କହିଲେ 1 ଲକ୍ଷ ଟଙ୍କା ନଦେଲେ ମତେ ଧମକ ଦେଇଦିଅ। ସୁନ୍ ବିଫୋର ଡେଥ୍ ଦିସ୍ ଷ୍ଟେଟମେଣ୍ଟ ହାଜ ବିନ୍ date of marriage 19/8/23 my lord. Occurrence 16/12/23 within 3.5 months of the within the period 3.5 months my lord. And yes, categorically stated my lord, regularly torturing by taking alcohol and my lord demanded 1 lakh rupees my lord.
But no external injury is there, my lord. No financial transaction between the petitioner and the in-laws from the.
If he has not given, therefore you have done it. Where is the transaction? You are in from December. Oh, just see whether the charge sheet has been filed.
Yes, ma'am.
When the rejection of
rejection of 13/2/24
and charge sheet
after
filed?
charge sheet 13/2/24
charge sheet filed on 13/2.
13/2/24
charge sheet, when charge sheet you filed?
charge sheet filed my lord
12/23 my lord.
Okay. Second
नहीं 17/12/23 एफआईआर ना
चार्ज शीट वो तो बताओ भाई। चार्ज शीट
कॉपी टा कहीं नहीं है इधर अच्छा आ गया अवेलेबल
14/4/24
14/4/24
then my lord
go to trial.
my lord
Go to trial. Right.
Surrender bail, my lord.
Petitioner is agreed by the order dated 13/2/2024, whereby his bail plea has been rejected. He is an accused, first bail plea is rejected. Subsequent thereto on date 14 14/4 the police has filed charge sheet against the petitioner inter alia alleging the offense under section 498A 306 498 306
49
charge sheet.
Yes,
498 capital A 304B 4 of DP Act 306 406.
However, the FIR was registered against the petitioner for alleged offense under section 498A/3/304B/34, read with section 4 of DP Act. Since the charge sheet has already been filed and the petitioner had approached the court below for grant of bail at the stage of investigation, it would be expedient for the petitioner to approach the court of first instance. Therefore, I am not entertaining this application, rather granting liberty to the petitioner to approach the trial. Yes. Next.
Let's say kind of pass it over here. Let's say.
Pass over. Yes. Yes, madam.
Offense under 274, 75, 76.
274. Custody?
Custody since January 18, 2024.
January?
18,
18 January 24. Okay. Show me the allegation. Yes. Do you have the record?
Yes, my cough syrup, my lord.
Cough syrup.
Top syrup,
two of similar price, my lord.
No,
And that is
quantity recovery. They
Cough-
found 175
Cough
numbers of cough.
and that apart, my lord,
cough syrup.
present petitioner involved in 8 cases, my lord. 2 are NDPS.
2 NDPS.
Yes.
And majority is in 2014, my lord. All cases are in 2014.
नहीं 22 रे NDPS गोटे अछि.
See your credential. Why should you come out? September last. Wait. September last. 64.
Maybe lordship. It's in custody since my lord. 6/2/2024. Being implicated a case on my lord. 420, 467.
420.
Yes, my lord.
Custody from?
Custody 6 February 2024, my lord.
24.
Yes.
ଏଥିରେ ଆଜ୍ଞା ଆସିନି କେବଳ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ଯେ 72 ଲକ୍ଷ ସମଡ୍ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର took from the informant my lord for higher return 72 lakh somewhat he has taken, and similarly 3 cases he involved another 3 cases.
So how many people you have cheated so far?
No, my lord. But it is business transaction, my lord. Let's say charge sheet shows 32 lakhs transaction, 32 lakhs. The business for purchase and sale of old vehicles, my lord. Only to my lord, made out a case of
You
420.
have taken the money, you have not neither given vehicle nor the
No, but
money back.
this is a business transaction, my lord.
Business transaction doesn't mean that you will take the money.
No,
What
my lord.
kind of business?
In fact, my lord, 23 lakhs transaction, 23 lakhs, and already returned 10 lakhs.
Why don't you settle with your complainant?
That's the next to
Additional. You,
Yes.
you go and settle and come and I'll get it cost.
Yes, my
File
lord.
482.
Milord.
Why unnecessary facing this?
Next.
Yes, additional. Yeah.
65.
Permitted to withdraw.
Withdraw. That's the best thing you can do. Yes.
Please, your lordship, Miller. Here, Miller, no contraband article has been recovered from the possession of the petitioner. Custody, Miller, 27/11/2023. 23. Here is a case. Look into the affair. The informant Miller alleged that on basing upon a credit information, he went to the spot and found Miller contraband article kept in a near a roadside. And accordingly, also charge sheet Miller, basing only on the suspicion, I got a reliable information. But in which source Miller the information and whatever Miller, no witnesses identified.
Where were you that time?
ମୁଁ ଗୋଟେ ନଥିଲି ଖାଲି ଗୋଟେ ଇନଫରମେସନ ପାଇଁ କେହି ବି ମତେ ଆଇଡେଣ୍ଟିଫାଇଡ କରିନାହାନ୍ତି ମୁଁ ବି ଘଟଣା ବେଳେ ରଖୁନ ରାସ୍ତାରେ
Milord, what happened, Milord?
He says no conscious position.
I'm placing conscious position. Milord, case of 21, Milord. Witness have seen Milord, present petitioner ran away from the spot, Milord.
Yes.
Total 1 quintal 82 ganja available at the spot, Milord. Subsequently, MW issued Milord on 10/11/24. He was arrested. I'm placing statement of that Saraj Kumar, Milord. Yes, category. Yes, Behra.
Who is he?
ମୁଁ ଥାନାରେ ହୋମଗାର୍ଡ ଭାବରେ କାମ କରେ ହୋମଗାର୍ଡ ଷ୍ଟେଟେଡ୍ ମିଲର ସମୟ ପ୍ରାୟ ଦିନ 10 ଘଣ୍ଟା 45 ସମୟରେ ଆମେ
Limited, my lord. But CD call for earlier occasion, my lord, on 3/4/24, my lord.
No, 1 minute. Rejection, charge sheet filed on?
My instruction.
I have no instruction of this CD given, my lord, earlier, my lord.
Preliminary charge sheet.
During course of investigation, this application before the
Charge sheet filed on when? Date, give me date.
Passover, my lord.
Passover.
Passover.
Give me the date of charge sheet. Yes.
69.
May I please your lordship? I mean, BC, my lord.
Yes. Yes, Mr. Mishra. Yes.
My lord, may I please your lordship?
Yes, yes.
My lord, custody 2012-22.
22. Yes.
My lord. Offense is 302, my lord. No eyewitness. And FIR is unknown FIR, my lord.
Charge sheet.
Charge sheet submitted.
Charge sheet already submitted, my lord.
1 minute.
The deceased is a widow lady, my lord. Having one daughter, after marriage of daughter, my lord, this petitioner one is the nephew of the deceased. He always wanted to take care of the proper 2 acres property, landed property of the deceased, my lord. That or what happened, my lord, a dead body was found, my lord. And grammar key law the information. Thereafter, my lord, nobody claimed the dead body, or identified the dead body. Thereafter, my lord, that has been, my lord, sent in a police personnel group, my lord, where the son-in-law of the deceased came to know that this photograph belongs to deceased, and came there and found that this is his mother-in-law. Thereafter, my lord, he stated that there is an enmity between the petitioner one and the deceased. Deceased, in order to grab the property, might be committed the offense. Thereafter, the petitioner, in order to grab the property to cultivated land, committed the crime. Thereafter, my lord, what happened? The petitioner was arrested on suspicion. He led the police and gave a recovery of the not a weapon offense, but the pant where the blood stain was found, my lord. And thereafter, basing on the confession statement, he has been
pant. Whose pant? His own pant.
Accused pant. That is the leading to discovery. And so far, I know eyewitness there. That is correct, my lord. But in fact, there is a link, my lord. The motive is there. He wanted to.
But except the pant he was wearing on the date of incident, nothing is there.
Nothing.
Yes. Your pant is recovered at your instance.
He has given the.
No.
How to get out of it? These circumstances. Very strong circumstances.
And the aunt, my lord. Aunt of the.
Only leading up discovery is the shirt.
Pant, he says shirt.
That's a full shirt.
Blue color shirt.
Full shirt.
Okay, your shirt. Your shirt which you are wearing.
My lord.
There the
ସେଠାରେ ପହଞ୍ଚିବା ପରେ ମୁଦଲା ସୁଭାଷ ମୁଣ୍ଡା ଶାଳ ଗଛ ପାଖକୁ ନେଇଗଲା, ସେଠାରେ ଲୁଚାଇ ରଖିଥିବା ଏକ ନୀଳ ରଙ୍ଗର ଫୁଲ ସାର୍ଟକୁ ପୁଲିସ ବାବୁଙ୍କୁ ଦେଖାଲା, ଯେଉଁ ସାର୍ଟରେ ହାତ ପାଖରେ ରକ୍ତ ଛିଟା ଲାଗିଥିଲା। ପୁଲିସ ବାବୁ ସେ ସାର୍ଟକୁ ଆମ ସାମ୍ନାରେ ଜବତ କଲେ।
How will you get
No
out of
antecedent?
it?
No
Antecedent,
antecedent?
leave. It is a murder. It is a murder. What antecedent? One
My lord.
antecedent is enough. How will you explain this recovery? If something else I can understand, the blood stain in your own shirt, the recovery, dangerous recovery. You are in custody since
2012, 22.
Trial has not, my lord, obtained, my lord, but in fact, charge sheet has already been submitted.
The petition, petitioner is in custody from 20th December 2020. First paragraph is the trial, only allegation against this, the present case is based on circumstantial evidence. The only allegation which is only connecting evidence which has been collected by the police is that his disclosure, on the disclosure of the petitioner, a shirt, his own shirt has been recovered, where the blood stain has been found. The state circumstances is a very strong one to presume the involvement of the petitioner. Therefore, the trial court has rejected the bail plea of the petitioner. I am also not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to renew his bail plea after the material witnesses are examined, or after 6 months, if the trial is not proceeded as expected, at the expected pace. With this liberty, the petition is disposed of. Yes, next.
May please, Your Lordship.
Yes.
This is not a usual case of 376. Why I'm saying, Lord, is a case counter case. Annexure 1 and 2 are the two FIRs on the same date. Fact remains, my lord, the
there are two FIRs.
Yes.
You are accused in second FIR.
First FIR I am the accused.
Second, what is the second FIR you have filed?
My wife has filed, my lord. What happened, my lord, the fact is that like this, my lord,
And
10 custody, my lord, he surrendered on 18 January 24. Voluntarily surrendered, my lord.
164.
Charge sheet has already been filed and statement has already been recorded, my lord.
164.
Yeah.
So,
And my lord,
And
medical
for the
exception
informant, Your Lordship.
is also there, my lord. I have also annexed to my petition.
let us see 164. Let us
Informant in this case.
Unmarried girl, about 47 years. 47 years unmarried.
47. Okay.
ମୁଁ ସୁଷମା ସାହୁ ଆଜି ଆପଣଙ୍କ ନିକଟରେ ଉପସ୍ଥିତ ହୋଇ ମୋର ସ୍ୱଇଚ୍ଛାରେ ବିନା କୌଣସି ଚାପରେ ପ୍ରଭାବରେ ଏଇ ବୟାନ ଦେଉଛି ଯେ 2 ଦିନ ତଳେ ରାତି ପ୍ରାୟ 10ଟା ବେଳେ ମୁଁ ମୋର ଘରେ ଶୋଇଥିବା ସମୟରେ ଆମ ପଡୋଶୀ
interest there is a dispute and all. Medical support doesn't, medical evidence doesn't support.
Miller annexure 1.
Maybe his specs and paint, whatever is recovered, there is a sexual intercourse or not, prima facie there is a doubt because of the medical evidence. So he is entitled for bail at least.
Annexure 2.
Subject to antecedent. You tell me antecedent.
My lord.
One second,
you want rejection now or
no,
bail on Monday?
Obliged, my lord.
Either of these two. Rejection now or bail on Monday?
Monday, my lord.
Monday.
If my
Wait.
friend my lord decided, then I'll
I'll Your Lordship,
Antecedent you file so that if he has an antecedent, then we can look into it.
Obliged, my
But he is entitled. He is entitled for it.
lord. Next week, my lord.
Yes. Okay. You also please verify antecedent.
I'll verify.
Yes. Yes.
May I have your lordship's, my lord? Petitioner is in custody since my lord 19/12/2023.
19/12?
23.
19.
The allegation against the petitioner 376(2)(n) and other alleged offense.
Charge sheet filed?
Charge sheet
My lord.
filed.
When have you filed?
Charge sheet filed on 24/2/23.
24/2/23.
Two charge sheet filed. Preliminary charge sheet 2/24 and final charge sheet 24/4/23.
24/4/23,
my lord.
23. Okay. What is the offense?
My lord, both the petitioners are major, my lord. And
376.
My lord, 376. In 164. In 164.
In the, I don't know why in this code only 376 are. Huh?
Other files are there, my lord.
164 read, 164.
164, my lord.
Already in the custody
No.
court.
हिंदी में है।
हिंदी में
हाँ,
थोड़ा सा खास। मैं गोवा में जब थी तो मैं वहाँ मेस पीजी 3-4
3-4 लड़की
रहती थी कुछ दिन के लिए
कुछ दिनों के लिए कंपनी ने हमें छुट्टी दिया। उस वक्त मेरी मुलाकात समीर नाम के एक लड़के से मिली। ये 2022 की बात है। फिर हमारी दोस्ती हो गई, फिर रिलेशनशिप में आए। हम एक हुए, अपने आप को प्यार का इजहार किया। हम दोनों के बीच फिजिकल रिलेशनशिप भी था। फिर मैं प्रेग्नेंट हो गई और बरहमपुर में ले आया और वहाँ एक मंदिर में शादी किया। फिर हम गोवा चले गए और वहाँ वह जबरदस्ती करके मुझे टैबलेट खिलाया और मेरा बच्चा गिर गया। कुछ महीने के बाद एक दूसरी कंपनी में काम करने लगी। जब मैं रहते थे कोर्ट मैरिज के लिए बोलती थी।
छोड़ो यार।
The occurrence taken place at Goa, some part of and
normal paragraph. So 19/12/2023. The petitioner, the victim has been examined. The victim has given the statement and the section 1 CRPC. She intrinsically stated that he has been in relationship with the present petitioner since 2022, and they had sexual relationship since then. As a result of which she got pregnant and once in Goa. He alleges that the petitioner administered some medicine, as a result of which 73 pass over. 73 pass over. Okay.
Also 376.
73 pass over, my lord.
73 pass.
75.
74. Withdraw.
74.
Yes.
Victim has love affair with the petitioner and inner 164 statement 75.
The best thing is when you appear in a matter, so all serious matter you appear, but you want to make it so simplified.
Because my lord, inner 164 she stated that
67 information technology, 67 viral, huh?
No, viral nahi. 75. More भूल ही गए.
75.
Oh,
7. You are somewhere else.
Sorry, 78 more.
Okay.
आगे अपना प्लेस.
Yes, Ms. Panikdai.
May I please your lordship? Lordship, this
Yes.
is under section 376, 294, 506 of IPC read with 67A, 66E of ITA.
Yes.
Lordship, the allegation is that the complainant and petitioner were in love relationship from past 3 years. And the complainant alleged that the petitioner kept physical relationship with him with false promise of marriage.
Read 164. You are in custody since?
That's if I'm in custody since 26/12/2020.
26/12.
26/12 December.
And 2020.
2023.
23. Okay. Okay. Read the that part. Relevant part of 164.
Lordship, ମୁଁ ଓ ସରୋଜ କୁମାର ସାହୁ ପରସ୍ପରକୁ 2021 ର ଭଲ ପାଉଥିଲୁ। ସେ ମତେ ତାଙ୍କ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିବାକୁ
By the time case were called for my lord.
Lordship, I'm just submitting, but the charge sheet has been submitted under section.
Let him bring.
Lordship.
I will obtain this.
You CD call for the CD. Okay.
Lordship, the charge sheet has been submitted.
Let the prosecutor bring it. on record.
Up to date
If you are entitled, you will get it bail. No, 302. What is
They are, my lord, when they are filed antecedent.
Antecedent bail. I know, I understand. Proceed. Yes.
But just I am
How did I
submitting. But another thing, he may take instruction. There is a compromise between both the parties. And I will 302, no, 306. Charge sheet has been
Whatever. What compromise?
They have
You
taken-
bring that on record. That may be a ground for bail, but not
Lordship,
anything else.
Lordship,
You can bring it on record. Why should
They
they
have
will verify?
This is already expired.
this is expert. The informant has taken.
You have gone up to settle with her.
No, Lordship.
Kill someone and settle with her.
No, Lordship, the alleged.
You bring those things on record, we'll see. That may be a value for grant of bail, but I think, yes, 78, huh? 77. Okay. Yes.
Initially, FIR was registered against unknown person under section 302, 34 of IPC. Subsequently, during investigation, the present person was arrested on 2011-2023, my lord. He was forwarded under section 302 of IPC, my lord. Here, my lord, two things.
CD is there, CD.
Yes, my lord, CD available.
Here, my lord, two things are there, my lord. Last in theory and the leading to discovery of a weapon that is a knife, my lord. And what happened, my lord?
Sorry from him,
My lord.
at his instance.
My lord, that what happened, there is prior dispute is there because the elder brother of the present petitioner love affairs with the informant's daughter, my lord, that the deceased sister. Subsequently, they fled away and married. From that time, there is a disturbance between the petitioner and the informant, my lord. And my lord, there is large sin theory is there that the petitioner and the deceased, they were both in the same mela. That a mela was there in the same mela.
Charge sheet you filed?
Charge sheet was submitted on 17/3/24.
Charge sheet file, and in the meantime, 14 witnesses have been examined.
Rejection order is, my lord,
The
2/3/24.
petitioner is agreed by the order dated 2/3/2024, whereby his bail application has been rejected. Thereto, the police has filed the charge sheet on
17/3/24.
Since the petitioner's bail application was rejected by the court below at the stage of investigation, petitioner is granted liberty to renew his bail application before the trial court on the changing circumstances. With this observation, the petitioner is disposed of. Next. Huh? Next. I'll just come. 5 minutes. Mentioning 2 o'clock. Yes.
28 ବୋଲେ ଏଥିରେ ନା ଭାଇରାଲ ଅଛି କିଛି ନାହିଁ ଏଥିରେ ଭାଇରାଲ ନାହିଁ
Charge sheet submitted under section 363, 376, 2N, 419 and 6 POSCO, my lord. That the present petitioner is a year of 29 years, having 2 child, my lord.
21/12/2023
He identify himself as an IS officer. He also makes some chatting with the minor girl.
That more dangerous than viral.
Minor chatting.
Child, the victim child,
Age 16, my 16 years, 10 months, and my chatting, my lord, that in Hon'Ble Siddharth Sankar Mahapatra, Bolangir Chanchal Rana, in Rayagada, he himself as the IS officer collector. With the assurance that he has kept the
ସ୍ତ୍ରୀ ମତେ ମାଇଲା ମାଇକି ତାଙ୍କ ଘରେ ଯାଇ ଝଗଡା କଲା ବୋଲି 2 ମାସ ପରେ
but see, the problem with you is you are 29-year-old. The girl is 16-year-old. And you are married. And
phone ରେ ଖାଲି କଥା ହେଇଛି
this is your intention is completely, you know.
ଖାଲି phone ରେ କଥା ହେଇଛି and that to be my wife ମତେ ମାରିଲା
See,
164, my lord.
Any sexual intercourse.
FIR ମିଲର ହେଇଛି ମିଲର
Yes,
One minute, boy. If the sexual intercourse is
my
there.
lord. My reading portion, মানে 11%. গত জুন মাসରୁ ମୁନା ମିସାଲ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ଫୋନ କରି କହିଛି କି ସେ ମତେ ଭଲ ପାଏ ମ୍ୟାରେଜ କରିବ ବୋଲି। ସେପ୍ଟେମ୍ବର 18 ତାରିଖରେ ମୁଁ କଲେଜ ଗଲା ବେଳେ ପାଖାପାଖି 9ଟା ସମୟ ଜଙ୍ଗଲ ରାସ୍ତାରେ ସେ ମତେ ଦେଖା ହେଲା। ମତେ ଜବରଦସ୍ତି ବାଇକରେ ନେଇ ଟିକିରିର ଗୋଟେ ଲଜକୁ ନେଇକି ସେଠି ରାତିରେ ମତେ ରଖିଲା ଏବଂ ରାତିରେ ମୋର ସହିତ ଜୋର ଜବରଦସ୍ତି ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା। ତା ପରଦିନ ଆମେ ସିଦ୍ଧବନ୍ଧ ଗ୍ରାମକୁ ନେଇକି ଘରେ ରଖିଲା। ସେଇଟା ତା ଦାଦା ଖୁଡିଙ୍କ ଘର ବୋଲି କହିଲା। ତାଙ୍କୁ କହିଲା ମୁଁ ତାର ସ୍ତ୍ରୀ ଓ ସେ ମୋର ସବୁଦିନ ଶାରୀରିକ ସମ୍ପର୍କ ରଖେ। ତା ସ୍ତ୍ରୀ ଓ 2 ପିଲା ବୋଲି ମୁଁ ଜାଣିନଥିଲି। ଦିନେ ତା ସ୍ତ୍ରୀ ଆମ ଘରେ ପହଞ୍ଚିଲା ଓ ବାପା ମାଙ୍କୁ ଧମକ ଦେଲା। ତାପରେ ମୋ ମା ମତେ ଘରକୁ ଆଣିଲେ। ସେ ମତେ କହୁଥିଲା କି
stage of the trial.
Stage of the trial is not with you.
petitioner is a 29-year-old.
I will take in instruction whether examine hai ki nahi, lekin medical examination kichhi nahi.
I'm rejecting it to revive after the
examination of the fifth case. सोमवार दिन रहो मिलो.
After 2 weeks. After 2 weeks. Yes.
दी मासे परे.
See, problem is you are 29, you are married. Thereafter 16-year-old girl and you are misleading her. And if you are not married, I can understand. You are married, having 2 children. Sometimes you are saying an IS officer, sometimes saying something. All these things, you are intentionally.
ମୋ ସ୍ତ୍ରୀ ଆସି ତାଙ୍କ ସାଙ୍ଗେ ଝଗଡା କଲା ବୋଲି 2 ମାସ ପରେ ଏତଲା ଘଟଣା ହେଇଛି.
Then only she might have come to know about all these things. She is a 16-year-old girl. See the age difference.
ତାଙ୍କ ଘରେ ରହି କିଛି
after 2 weeks.
79 টা Arjun.
After 2 weeks.
79. Arjun ji.
Mention ki good करते.
ना ना. भूल गए और थोड़े.
You na?
No.
You are appearing in 79.
Yes, sir.
For petitioner.
Yes, madam.
It is a bail matter. How can somebody else will mention it? Mention it.
Next case.
What is this offense?
294, 394, 25, 27 arms act. Custody from 4/11/23.
4/11/23. What are the allegations?
Allegation मतलब 15,000 टका नहीं गला एवं मोबाइल फोन.
In this case, my lord, he was remanded because there was another antecedent against him where he was in custody. So in this case, he was remanded. Silver anklet was seized from the present petitioner. My lord. It was reflected in the.
What about the other case? He's got
bail.
How many cases are there?
Two, my lord.
Only. The other case, in that case, these are confessional statements.
Yes, madam.
In this case,
yes,
confessional.
You are right.
And why anybody has mentioned it? Who?
I don't know.
Can it be taken up tomorrow? Because somebody mentioned, maybe I don't know for what he has mentioned.
File with me.
Has he also filed the Vakalatnama for this accused?
No.
Yes. This is the other case, huh?
Yes, madam.
Where you got the bail. Right. Petitioner. He is on he is in custody from 4/11/2023. I'm granting bail.
Right.
Petitioner custody in Hari Charan PS case number 164 of 2023.
There is another case, 167 also there.
There are 2 cases.
Two cases. Excepting that case, there is another 2 cases. One is under section 394, another is 392.
In which case he was in custody and gave
that is in 70/23 Doitari PS case. And here he was involved in Harichandan PS case, Harichandanpur PS case number 164 in 2000. In the other year,
then according to you, there are many cases. So this is 89 FIR 89. Okay, Balechor.
My lord, this is FIR number 70.
Huh?
70/23.
70
by 23 Doitari PS.
Which case is this here?
That's 79 item. My
Bablu Jena.
Yes, madam.
Bablu Jena.
What is this FIR then? The one which you have filed here. This FIR is 70. Okay, this is 70.
My lord.
Then he has another case.
Another 2 cases. Another 2 cases, 167. I would 164.
He was in custody in which case?
He was in custody in
when he gave the disclosure statement. And Harichandan PS case 167 of 2022. While in custody, he appears to have disclosed that he is also involved in FIR number Daityari, PH case number 70 up to 2023. Therefore, he was taken on remand in that case also. Insofar as the earlier two cases are concerned, this court had already granted bail by the order of the except the disclosure statement of the petitioner, which led to disclosure statement of the petitioner, which led to recovery of what? Recovery of
Anklet, my lord. One anklet.
Anklet. No other evidence appears to have been there in the record. Petition is in custody from 4/1/2023. Granted.
4/11.
Yes. Next.
Obliged.
May I please, my lord, on behalf of Mr. S.K. Devedi, kindly warn your captor.
Adjourn.
Obliged, my lord.
May I please, your lordship. The present petition is the husband, your lordship, custody since 29/10/2023. 29/10/2023, my lordship.
Okay.
Initially, FIR registered along with 302, your lordship, but subsequently charge sheet submitted 498A, 304.
That it's filed on?
Charge sheet filed on 27/2/24.
306 is there.
Okay. 306, huh?
My lord. Along with all.
306.
You are the husband.
My lord.
How many accused persons are there?
Only charge sheeted against only the husband, your lordship. Other name has been deleted.
My lord, evidence, my lord, PM report, there is viscera is awaiting, my lord.
Viscera?
Report. Viscera report is awaiting.
Awaited.
My lord. In the
shall I put it after 2 weeks?
My lord. 2 weeks and your free copy may be given, or I will communicate to the SFS.
The Council for the State submits that in the present case, viscera report is awaited. He seeks 2 weeks adjournment to ascertain the status. Lease the matter after 2 weeks. Free copy of the same may be supplied to students. Okay.
Free copy may be given.
Free copy. Yeah. Okay. Yes. After 2 weeks. Yes.
Please, Lordship. Lordship, petitioner custody since 9/11/2023.
9/11?
2023. Lordship, offense under section 376, 3 IPC and 4 POSCO Act, Lordship. Lordship, in this case, charge sheet file on 6/1.
What is your age?
Lordship,
Is
victim
32.
age
is 12 years.
12 years, Lordship.
Date of birth
You are
is
32.
I am 32, Lordship.
What are the allegations?
Lordship, allegation that she kiss and touch her cover body parts, Lordship, and send some
No sexual
intercourse. Petitioner victim denied for medical examination, completely denied, Lordship.
Yes.
My lord, there is some allegation passing over that 164 statement.
Read what?
No, my lord, there is some.
Give me. Is there any sexual
Can
intercourse?
see that some.
We can read it. Yes. There is no.
Lordship, no.
But my lord, that conduct, my lord, Lordship is that such type of conduct who is a minor who is 12 years old.
Lordship, petitioner send SMS to the victim mother, Lordship, not victim, Lordship.
What he says she is
12 years.
earlier plus. You are 32.
Lordship.
and your conduct is also the.
Lordship, come to the affair, Lordship. This is a cover body parts, Lordship.
I know,
Allegation.
not cover body part. You put your hands
Lordship, after
inside.
Lordship, on FIR, Lordship, I am starting.
No, FIR, I am
164 statement.
164. She is very categorical.
Lordship.
You are 32. You are married.
Lordship, yes, Lordship.
Married then. 12 years girls, the conduct, you are married. If the age gap is very less, then generally I grant bail.
Then our child is
Perverse.
Lordship,
Your conduct is completely perverse. 12 years girl,
12
see the
years,
conduct.
Lordship, petitioner relationship with the victim mother, Lordship. Not Lordship. With
Victim mother, you have a relationship, and daughter, you are doing all these things.
No, Lordship. His father is allegation. Doctor khali mobile SMS dakala, Lordship.
Wait till the victim is examined. Right, and peruse the.
Lordship, victim examination 12 तारीख को अच्छी. Lordship, 12 तारीख पर any date as well.
So you revive the bill right now. Petitioner is accused of FIR promotion. I have perused the statement of the victim 164 KRPC. The allegations are very serious against the petitioner. Petitioner is 32-year-old married man, and the victim is 12-year-old child. In view of the same, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail plea after the victim girl is examined by the court. And let counsel for the petitioner submits that the trial court has fixed which date?
12th, Lordship.
12th of this month, 12th for recording of evidence of the victim. In view thereof, the present petition is disposed of with the liberty to the petitioner to renew the bail plea before the trial after the examination of the victim.
My lord, another thing is that, my lord, though 376(3) is there, notice was served in both ways.
I am rejecting it. Yes.
Notice was served, my lord. That is on 6/4.
I reject. He will revive. Yes.
And only that may be mentioned that with notice. Though 376 is there, mandatory provision.
Trial court knows it. What is this? Trial court will do it. I am not doing anything.
No, my lord. That notice part is whether it was served or not to the victim. That was served on 6/4/24. That may be reflected in the order. Yes, ma'am.
Since the offense alleged is under section 373, notice was issued to the informant.
And it was served on 6/4.
However, none appears. None appears. Yes, next. 83. Yes, sir.
Your Lordship.
Yes.
Your Lordship, occurrence took place on 19/10/2023 morning, Your Lordship. On next date, on 20/10/2003, FIR has been lodged.
307.
307 converted to 302.
My lord.
302 converted.
Yes,
my lord.
Right, huh?
My lord, on 23/10/2023, the deceased died, Your Lordship. The petitioner was arrested on 4/12/2023.
12/23.
My lord, charge sheet filed on 25/2/2024.
5/2004.
That is preliminary charge sheet. 25 and the rejection order is 6/2/24. So he may. Rejection order 6.
Right on. Petitioner had approached the court.
26/2, Your Lordship.
Court below.
My lord, this.
The bail plea of the petitioner has been rejected by the court below on 26/2/2024. However, the subsequently thereto, preliminary charge sheet has been filed by the
my lord,
25/5/2024.
25/2, my 25/2/24.
25/2/24.
My
lord, in this case, Your Lordship.
1 minute. The investigation is still going on.
My lord, against me already charge sheet has been, maybe preliminary charge sheet, but I am in custody.
What are the allegations?
My lord, in this case, there is no eyewitness, Your Lordship. I am placing statement of one witnesses. Your Lordship will clear about the case, Your Lordship. मोर नाम चंडीलाल नायक आज 23/10/2000 तारीख दिन आपन सम्मुख देवा मोर
after the final investigation anything may come. How do I know?
Yes, my lord,
as of today these are the materials.
My lord, as on date there is no material against me, only the dog squad entered into my house, therefore I was arrested in this case. placing
And
the,
my lord, iron pipe was seized from the co-accused, my lord. They are the, my lord.
What is the allegation against him?
my lord, mate allow करने टिक submit करवा पाए मु
Yes.
submit कर दिले सब clear ही जीवा, my lord.
Submit तो करिए किसी फाइल तो करना है ना submit कौन करिए?
My lord,
I will have to depend upon him only. You have not.
my lord, I am submitting the 161 statement. He have also
You
that.
have not filed. I have to see him. I will have to see the prosecution.
My
only.
lord,
Have you filed those things?
my lord, he has copy of
So
CD.
then I should depend upon him or hear him. Tell me.
My lord,
Adjourn it for 3 weeks.
my
This
lord,
is no way. You don't file anything except FIR. You have not filed anything. I will have to depend upon him only. You hold some paper and read it out. Why should I believe you? Like you?
this paper is.
Try to understand the technicality. Therefore, I'm asking him. If you have filed these things on record, you read it. You are holding some paper and reading it out. CD is called for. I'll have to see him only.
My lord, your lordship asked him, your lordship.
And you are preventing him.
I'm not preventing your lordship.
Try to understand why I am asking. There is a reason behind it. You are reading some paper which you have not filed. The court has called for CD. The court has.
Your lordship kindly hear.
That is the point I'm don't prevent him.
My lord.
Please understand, there is a reason behind it. Don't mind. You have a right to be heard.
My lord, in the meantime, I will take instruction of whether the final charge sheet was submitted or not, because preliminary charge sheet was on the February.
I'm listing it after 2 weeks and
Yes, ma'am.
Mr. Misal and counsel for the petitioner submit that the preliminary charge sheet has been filed in the present case on 25/2/2024, but regarding the final charge sheet, status filing of final charge sheet, he would be seeking instruction from IO. Leave the matter after 2 weeks. And you do one thing, whatever documents you have, you file it.
Well,
so that even if he doesn't come with his document, I can read your document.
Yes, your lordship. Yes, lordship.
Except FIR, there is nothing here.
I am filing your lordship.
Yes. You too, and land counsel for the petitioner seeks liberty to place on record additional documents.
Yes.
You place it on the additional documents.
Yes.
Yes.
84.
Yes.
Item 84, my lord, on behalf of Mr. Chand, I pray for a passover.
So, okay, pass on.
5.
My lord, custody since my lord 19th February to 24, my lord, 395
19th February 24.
24. My lord, charge sheet filed, my lord, in 16/6 to 24, my lord. Against 6 persons, my lord, the present petitioner having no criminal antecedent, nothing seizure has been seized from his possession. My lord, only, my lord, the statement of the accused who has been arrested, and while he is in custody, they confess the name of the present petitioner, and he has been in custody since, my lord, February 2024.
See, you approached the court when the investigation was going on.
11/3/20.
Now the charge sheet has been filed.
My lord.
So you have to go to that court first, right? The petitioner is agreed by the order dated 19 order dated. Where is the order?
That is 11/3/24.
11 March 24.
11/3/2024, whereby his bail plea has been rejected. Subsequent thereto, on 16/6/2024, the police has filed the charge sheet. So therefore, the petitioner seeks to withdraw the present petition to approach the court of first instance, renewing his bail plea. I am not inclined to entertain this petition. However, liberty is granted to the petitioner to press the bail plea before the trial court, and if such application is moved, the same shall be considered on its next case. Next.
86.
Yes, sir.
In his offense 394 IPC, unknown affair, custody since 14/2/2024.
14/2/2024.
24. Yeah, the co-accused were granted bail by the learned court in session over the matter. Since I am having some criminal antecedents, I was not enlarged on bail.
How many cases are there?
10 to 12 cases.
Against the petition number 1, my lord, 13 CA. Against the petition number 2, 3 numbers of antecedent.
What kind of cases?
That unknown, say 379, 394. Almost.
You are very well.
My lord, against the petition number 1.
Where are the particulars of the case? What is the status?
My lord?
Status of those cases? 10 or
10, my lord, that is 13 cases.
13 cases
against the petition number 1. And 3 cases against the petition number 2.
You are on bail in all the cases?
Yes, I am bailing all.
File an affidavit.
Yes.
File an
Your
affidavit.
comprehensive
And
affidavit.
counsel for the petitioner.
Let's keep it next week any day. I will.
Submits that he would be filing an affidavit there, giving details of the antecedent and the status of those cases. Mr. Mishra and counsel state submits that the petitioner number 1 is involved in 13 cases, where petitioner number 2 is involved in
3 cases.
3 cases. So the counsel for the petitioner file an affidavit giving details and the status of those cases. Please the matter of case. Yes.
Let's keep it next week.
Yes. Next. 87. Yes. 88. 87 withdraw. Yes. 88. Yes, sir.
May I please, Your Lords?
Yes.
The case 376, my Lord.
Custody?
Since 2023, my Lord.
25.
2023. The
Only 376.
376 2N and 448 354.
Oh, forget. Any. Acha, 6.
Yes, I have. Yes.
What is your age?
Age, my Lord, 20 years.
20 years.
And age of victim is 17 years, my Lord.
Read the read the 160.
164 I have given.
You
me,
filed
Lord.
it? Okay.
Running page 15, my Lord.
15.
Yes, my Lord.
Read it out. They were in relationship.
Yes, they were in love, my Lord. On the day
Read
of
it, relevant
alleged.
part. तुमको आगुरु भलो पाउतिली.
Yes, ma'am. Thereafter, there were allegations that physical relation when 2 persons have seen them in a room, my Lord. Thereafter, this case has been lost.
I'm granting you. 20-year boy.
After that, he returned her and in the way he left her with his father.
Okay, 20-year-old boy, 17-year-old girl, they were in love. This is bound to happen. I am only looking at the age difference. If the accused is age difference is very much, and he is married and all, no question of
security of minor girls should be there also.
That's right. But see, this is the reality, harsh reality. These people are very young. They are not criminals. But there is a technical offense. What to do? If the intention is very bad, if he is a married guy or age difference is very much, so he should behave properly. If those kind of accused are there, they are not entitled. But it's a boy of 20 years and the girl is 17 old. And if he has viral the picture and all, then also I'm reluctant. He's not viral. I don't. Petitioner is accusing so. So the charge sheet has already been filed. The statement of the victim under 164 CRPC discloses, reveals that the victim has been in relationship with the petitioner. Although there are allegations against the petitioner made by the victim, however, fact remains that the petitioner is a 20-year-old boy and the victim is 17 years, and they were in relationship. The petitioner is in custody since 25/4/2023. With all these conditions, all the 2 conditions. Here. 89. Yes.
May I proceed? Offense under section 302 and 307, 341, 34 of IPC, my Lord.
Yes.
Petitioner is in custody 25/2/2022. 25 to 2022.
22. Oh.
Charge sheet was submitted 9/4/2022.
9/4/23.
Yes. Petitioner is in, when the occurrences took place on 13/12/2023, my Lord. The petitioner was in custody since another case, my Lord.
302, that is 302.
Yes, my Lord. The charge sheet column, I was submitted in judicial custody, my Lord.
You were involved in some other case.
Some other case, and he was granted bail by the Sonal court. After releasing bail bond was granted, and release order was there. The query, he found that another case is pending.
How does it help you? How does it help you? Rather, Rather
He
go
was
the
in
case.
custody. He was in custody.
At the time of incident, he was in custody.
Custody.
So me.
Yes.
There only he has made all this plan, Lordship.
No, my lord. He was in custody.
Only
Conspirator. Sitting in the
Yes,
jail,
yes,
you have
yes.
done it.
Okay.
Yes.
He was in
That's the
custody, my lord.
allegation.
Yes.
No, if not, my lord. 164 statement was recorded by the complainant, my lord. Yes. Only one statement.
What about the other accused person? They are in custody?
Custody.
They are in custody.
Those name in the
None of them.
See, if
No.
come also on the next day, another incident will happen because their conspiracy is continuing going on since 4 years.
This occurrence took place in 13/12/2022.
From one side,
He was in custody in the other case.
February was custody.
What was the allegation? 302.
Yes.
Oh.
He was released on bail, my lord. Nothing has been requested. In the meantime, my lord, the complainant has examined, my lord, PW1, my lord. He is hostile, my lord. I have annexed.
Hostile because of you are involved.
One will come on
Yes, well,
Because you are involved.
Yes.
Everybody will be hostile. Don't worry.
I am.
Everybody will be hostile.
During that time when I was in
And
custody.
during this period, whatever custody you have, that is the only penalty. And you will be acquitted. That's obvious. You are very strong man there. After last week of September. Stay for some time.
Especially that, my lord.
Yes.
Small prayer before your lordship. In the meantime, my lord, eyewitnesses has been examined and they don't have supported the prosecution case to produce the same.
What are the allegation against you?
Allegation 302.
302.
Only prayer next to may be taken. I will produce the copies.
Yes, is it true that eyewitnesses have not supported prosecution?
I don't have file the copy.
Okay, after.
Obliged.
Then counsel for the petitioner submits that meanwhile the eyewitnesses have already been examined by the court below and none of the eyewitnesses have supported the prosecution. Let him place on record the evidence of those eyewitnesses the matter. Yes. 91.
On behalf of Mr. SQD, kindly 1 week after.
Urgent.
Obliged, ma'am.
92. Offense? 302.
Yes.
Non-abuse for the petitioner in the interest of justice. Urgent. Yes. 94.
No, 92 I am there, my lord.
90?
No.
What happened 92?
92.
92? What happened? 92, huh? Yes, tell me. I just...
CD now.
Huh?
Now CD can.
CD.
Now,
Get
just now.
No, it 92.
92.
Connected. Yes.
Connected.
92 and?
92 and 94.
92, 94.
After lunch, let's take up. CD is there, my lord.
CD, but he has to read it. Huh?
Okay.
Let him read it. 92, 94. 1 week for a
Next week, my lord.
He has already, the state council has already received the CD, but he is not prepared. So, this is not next week.
Next week, my lord.
94. 93. Yes. 95. 95.
May I please, madam? I am from Jaipur.
CD he has not read the CD. He has got it. I will put it next week. Let him post.
Yes, yes.
Yes.
Yes. May I please, my lord?
Yes.
I am busy. Personally, is in custody since 23 out of 2023, my lord.
23? 23 July?
Yes, 23 August 2023.
23 August?
Yes.
Okay.
And
yes.
He is entitled in 7 cases, my lord, from which 2 cases he is on bail. In 2 cases. By VL appeal number 11525 of 23, 1 case, and ABL appeal 378 by 24. In both cases, he is enlarged on bail, and another
you
5.
Tell me what is the case against you?
409 and 13(1) of Prevention of Corruption Act.
Sorry, I couldn't follow you. Please repeat.
409 of IPC And 13 of Prevention of Corruption Act.
Okay. You are involved in 2 more cases, huh? Where you
I'm-
got the bail. That's what you mean to say.
I am involved in 7 cases. After 2 cases, they posted another 5 cases against me. And he's a 65-year-old man.
Your Lordship may kindly have a glance to the appraisal report sent by the SP, Vigilance Koraput.
Yes.
Paragraph, page 2, first para and last para.
Page 2.
Page 2, that is page 2.
Please read it.
First para and subsequently, Hon'Ble Court of Special Judge Vigilance Jaipur issued NBW against Sri Sahu on the prayer of vigilance to compel his appearance. Later sources were engaged to inform the whereabouts of Sri Sahu, and information was collected that Sri Sahu has been frequently moving and changing his place of abode in New Delhi and Jorhat, Assam. Accordingly, as per direction of government, a special squad was formed for his apprehension. The squad stationed at New Delhi and could manage to apprehend Sri Sahu after untiring efforts and taking lots of pain. Thereafter, Sri Sahu was produced before the Chief Metropolitan Magistrate Patiala House Court, New Delhi on 20/8/23 and further produced before the Hon'Ble Court of Special Judge Vigilance Jaipur on 22/8/23. Last para. Sri Ramesh Chandra Sahu, being an OAS and Group A officer, was due to retire on 31/12/2018 on superannuation. But to avoid the investigating agency as well as stricture of court, absconded from the office prior to 3 years of his retirement. Being an administrative and responsible officer of the state, while in service, when he could dare to abscond and only after continuous and ongoing efforts of vigilance officials, he was traced out beyond state.
See, if this is your contact, how
9 years.
the bail?
Your Lordship, may kindly present status I have given in second page. Of the cases, in one case he has been convicted and he has already filed one appeal bearing number CRLA 378 of 24. And other 6 cases are there and present status I have obtained today.
Have you gone through this?
Yes, my lord.
They are conducting lawyers in Koraput.
And he is in jail custody since last 1 year.
Maybe, but 3 years you have absconded, being a
9 years.
administrative officer.
9 years.
9 years, and now you be trusted like this. That only the written instruction has been placed on record. Placed on record. Have you read the written instruction which has been filed now?
Yes, I've.
You served.
On the previous occasion, Hon'Ble before Justice A.K. Mahapatra, I had served through WhatsApp. So let my prayer is, let the learned special judge be directed to dispose of the cases, other 6 cases.
6 cases.
Other 6 cases. In one case, he has been convicted. Other 6 cases are there.
In all the cases, he got
misappropriation.
All the cases he got the bail.
Maybe.
In how many cases you have got the bail?
2 cases.
In one case, 2 cases he has got the bail.
In 2 cases.
One is appeal and another is 196.
Appeal, obviously.
Appeal. And another case he had got the bail by the Honorable Coordinate Bench of this Honorable Court.
You file an affidavit. How many cases are there? How many cases you got the bail? And what are the stages? Land Council for the petitioner seeks 2 weeks time to file an affidavit detailing the cases pending against him and the status of those cases and disclosing whether he has got the bail in those cases or not, at least after 3 weeks. Yes.
And I filed it may be
that is taken out of
my appearance for kindly. And in the cause list, my name can kindly be reflected.
Yes.
My lord, I filed my IA.
This is how many cases he has filed? He has filed here 95, huh?
95.
1, 2, 3,
4,
5. I mean, all the cases, different cases.
All the cases, different misappropriation in different times. So when he
and
knew,
he seeks bail in all the cases.
Yes.
In one go.
When he knew that vigilance inquiry is going on, he absconded. His service was for 3 years to retire.
Better to target all the 5, 6 cases and fill.
I prayed before Lordship that that the learned special judge may be directed to dispose of within a year or within 1.5 years or anything else.
That's
better.
Otherwise, he will abscond again. If he is released on bail, he will again
There
abscond.
is no question of granting bail. Mr. Panigrahi, there is no question of granting bail. You give the affidavit. I'll target the
in other two cases, there is no.
Shall disclose the number of witnesses cited by the prosecution in all the cases. Accordingly, I'll just see.
In other cases,
I have given the list.
No number of witnesses.
Yes, number of witnesses and how many witnesses examined it. It has been given. Today I have received. Out of 21. No, ସେଇଟା ନୁହଁ ଆରଟା.
This one.
Yes, yes. First one.
First one.
Out of 2 cases, charge sheet is not filed.
Out of 21, your lordship may kindly have a glance.
Yes. You have given. During the investigation,
I have given out of first case, out of 21, 11
yes.
examined, 23, 9, out of 22, 3, as on 23, I have given that. Last but one column, my lord.
So let him file an affidavit.
My lord, yes.
Other two cases, charge sheet be filed in, my lord.
They are cases 12
and in few cases, charge sheet has not yet been filed.
Yes, it has been written in the said. Charge sheet is under progress. In the letter itself, it has been indicated.
You just see when you can file the charge sheet.
In case to equity and in that letter, your lordship may kindly peruse.
That's right. You file the charge sheet at least.
Yes. In last but one paragraph.
Let it come after 3 weeks.
Prosecution has been received from government. Sanction has been received, and charge sheet in both the cases are under preparation.
File. Okay.
It has been written in that letter.
96.
May I, lordship? In this matter, my lord, I filed an IA for interim. Let's say 302 offense, my lord, in custody 1523.
IA?
Yes,
Where
my
is
lord.
that
Here, my
IA?
lord, his mother is my lord died. Dated my lord 5/8/24. Some document, my lord, is that in the date of 5/8/24, my lord.
Yes. Will you verify it?
Tomorrow 10th he is saying.
बुधवार 10th. 5/8/24, my lord died. So,
To me.
that is a document issued by the Sarpanch and the chairman of that locality, my lord.
Let us.
Yes.
2 weeks. Huh?
My lord.
1 week, lordship.
Then
2 weeks.
the petitioner has moved the present application interim application seeking his release for a limited period in view of the fact that his mother has expired on 6/8/2024.
5/8/24.
5/8/2024. He has placed on record the certificate obtained from the doctor. Nay, obtained from the Panchayat Samiti.
Panchayat Samiti and chairman.
Chairman of Panchayat Samiti. And why there is nothing else? How will you believe these people? They can write anything.
My lord, my version also let me record that. That is true, my lord.
Panchayat Samiti certificate.
गरीब ऐसा लोग का समय इटा आने की
The problem is Panchayat Samiti they are not authorized to give certificate whether he is died or he is not died. Some death certificate, something you have to show.
There was घरे से बने he died my lord in house, my lord. That is and old age में cardiac.
Verify it tomorrow.
Tomorrow.
Huh? Verify it. Please. Panchayat Samiti regarding the same. Is directed to verify the same. Lease the matter tomorrow. Verify it. Give a copy. Verify.
They already submitted.
You ask the IO to give a report so that I grant.
37.
See, you have to do it tomorrow. Don't ask for time because day after tomorrow he has that.
Yes.
So tomorrow in any case you have to leave him. And take it as a first item. Huh?
My lord.
Take it as a first item.
Okay.
Tomorrow. Yes.
1
minute. Can you verify it in the afternoon?
Yes, I will get. I will try to get.
I am passing it over.
My lord.
No, passing over because see tomorrow if I'll release by the time he will complete the formality and this thing will. I am passing it over just in lunch time. Even at 4 o'clock I'll take it up.
My lord.
Yes.
7. May I please, your lordship? Am I audible, lordship?
97, now CD came. Just.
Lordship, am I audible?
See, he got the, yes, but he got the CD just now. He 6 weeks time to read at least. I'll put it next week, okay?
Lordship, only constraint is that I have got an antecedent.
That's right, but he has got the CD. The court has called for CD. He is entitled to read it at least.
Lordship, on the last occasion, your Lordship has released me on bail. Granted me a bail. But owing to that antecedent only, I couldn't avail that bail opportunity.
Okay, I'll see if you have a case, definitely next week, huh? Next week, huh? Next week.
Deeply obliged, Lordship.
Yes, next week. Okay.
98.
I have.
Yes.
Fine. I have filed this writ petition challenging the orders under Annexure 11 and 14.
Is it a special assignment?
Yes. But the rule with regard to appointment of the principal in charge in the aided colleges, the senior most teaching staff, approved teaching staff shall be continue as the principal. That is the law. The government, and I have challenged that.
I'll take it at the end of the list.
Pardon?
I'll take it at the end of the list today.
Actually, my lord, it has come under orders.
Because I am the hangover of who is in custody 376 and all that.
I was also thinking, I was sitting here and amazed.
Your facts will be mixed up.
Because I don't have such type of cases.
My learned senior has challenged the which notification he has challenged, and he has complied the order of the sub collector, and that same is he has challenged before the lordship.
No, that is not the way.
So that is that he once he is complying.
By the way,
yes.
Once he is complying the same and he is challenging the same.
My lord, the key of this order of the government.
Show me the impugn order.
Page 31.
31.
But therefore, I am just stating the background. 31 is an order of the government directing the president governing body to submit somebody else's name to function new principal come secretary of the institution.
Your challenge is regarding the appointment as a principal.
I am the principal in charge. I have been continuing by virtue of a court order, this court's order.
And now somebody else is.
Now the government is directing to overreach that order of this honorable court. Now he is directing like this, page 31 may kindly be seen.
Right. Yeah.
Well, I got it. Inviting reference to the above notes, I am directed to request you to furnish a fresh seniority list as per the revised formal along with the data set suitable to each recommended lecturers for consideration appointment new principal come secretary of the college.
On the basis of the seniority.
Seniority and the senior most. That has been held by this court and the documents are also there on record. So at this juncture, my lord, and steps have been taken by the sub-collector.
Where is the seniority list? Show me.
Kindly see, my lord. The seniority list, that is 14. Page by 43.
43. 43.
Yes.
Yes.
That is part of Annexure 14. Very good.
Where is the seniority list?
My lord, this is the list.
Okay.
Page 43.
Okay.
Well,
Your name is at?
This petitioner is the number 1. Sudhir Kumar Raut. Date of joining is 27/4/1992.
Yes.
And the next one is Prabhakar Jena, is 9/1/93. 3 is.
And by virtue of what you read it out,
Maya.
And these people would be beneficiary.
No. I am already in.
You are already there by virtue of court order.
Yes.
But if that is given effect to, then these people, one amongst them replace you.
Yes.
That's your apprehension.
2 and 3. Yes.
Apprehension.
I am at the serial number 1. My name is
you
there.
Come to your memo. Memo parties.
No, that is
Come to your memo.
No. There is this action I have challenged, my lord. My lord asking for the memo of charges.
Memo parties. Memo parties, cost title.
Cost title.
Yes.
So because I am challenging the government order.
You have to implement them.
No, my lord, they are neither the necessary nor the proper part.
No, they are necessary part.
My lord, I am.
This is, if any order is passed, their right is affected.
No, if My respectful submission at this,
Suppose I allow that petition.
my lord.
Their right is directly affected.
No, no right accrued by them.
That will, they will say, or you can't decide their.
No, that is the law led on by this honorable court, man.
Show me what.
Only when, because the law, what the government has decided in a particular circular on 31/8/92/2020,
Right.
the security will be based on the date of birth, not on the date of journey. That was the this was why all these litigation starts, man. I came to this honorable court. Many cases were
That's
for
right.
this honorable court, and the judgment came.
Date of assuming office, you seniority will get it.
That is the law.
That's the law. There is no problem.
That,
but the problem is you are challenging an order by which the department has asked for the seniority list to look into whether you will continue or some other person will continue. Some other persons are reflected at page 40. Yes. You have to implement them.
I am one of the beneficiaries who have
That's
intervened. And my IA is pending with
application for implement.
yes, my lord.
This
And
is
flag B. Well,
that's bound to happen. Everybody will keep coming. And suppose I allow today, somebody will file a petition saying that I am not heard. Then you are gone.
My respectful commission is.
Why to get over? Why don't you implement? I'll put it next week. Implement these people.
my lord, can we allow my...
There are only 3-4 people.
Yes, yes.
Implement them. Why to
all right.
Invite technicality against you? You implement. Learned counsel for the learned counsel for the petitioner seeks to implement likely affected parties in the from the seniority list dated. Where is that seniority list? 40?
Yes, 43.
43. Yeah, 43. 43. 43 me. Yeah. 43. 43. No, 43. Yeah. No, not 43. You have shown me something else. 43. Acha. Okay, 43. Yeah. He may do so within a period of 1 week.
2 weeks, my lord.
Okay. 1 week. Lease the matter after 2 weeks.
No, 1 week, because this maybe I personal difficulty.
Okay.
Within 2 weeks, I'll file it.
2 weeks. Issue notice to the newly implemented respondents, returnable within 2 weeks. Lease the matter. And file amended more parties to be filed by next day.
My IA also may kindly be allowed.
IA automatically allowed.
Automatically.
And then many IA will come, and if I allow, and they'll challenge it saying that we were not heard. Unnecessary. And you have a difficult case. I am allowing your implement application, but you have a difficult.
There is. Let that entry model to continue.
Entry model to continue. Get ready. Your application is automatically allowed.
Yes, ma'am. I will file my counter affidavit.
Yes, file the counter.
Oh,
Yes.
99.
I know. In view of the aforementioned order, the IA number so and so stands allowed, and the implemented respondent shall file the counter within 2 weeks.
Within 2 weeks.
Yes.
99.
On behalf of Mr. Chand, my lord. My lord, we have to file the certified copy of the warrant order, my lord. Not received it yet.
You tell me what is this case is about. NVW issued.
Yes, my lord.
Huh?
Yes, my lord.
Forget about certificate copy. You tell me where is that order. NVW, I'll quash the NVW. Go on appear. Where is the NVW order? Where is that order? Are you challenging the cognizance order or NVW order? You tell me.
My lord.
NVW, straight away I will pass. Forget about the certificate copy. Go and appear. Why are you wasting time? Are you also challenging the cognizance order?
Oh, no, my lord. NBW was passed on 9/11/2017, my lord.
So I'll pass it.
My lord.
Or see, be sure about what you are saying.
My lord, may pass it over, my lord.
Yeah, I'll pass it over. See, read the prayer. It's a composite prayer. Therefore,
yes, my lord.
you will be in trouble. Composite prayer that cognizance order dated 9/1/2017 and subsequent issuance of NBW.
My lord.
When the NBW was issued, you tell me, I'll quash it. But you have a challenge to cognizance order also.
Yes, my lord.
So you just, I'm passing it over, stick inside.
My lord. My lord.
If you want only NBW order to be quashed, give me the date, I'll quash it. Okay,
My lord.
pass out. Yes, sir.
In this case, your lordship issued notice through IO, my lord.
Yes, any
Yes, yes.
instructions?
Notice sufficient, my lord. Mr. Receipt.
Yes. Yes.
My lord, kindly have a glance to page 11 of my
What have you
corrective
asking?
application.
Quashing of what?
Quashing of cognizance, my lord.
Yes. Offense?
Offense, my lord, 376. Your lordship have a glance to page 11.
Yes.
I, Padmavati Naik, so and so, so and so, that due to some misunderstanding between it and the accused person, that is me, my lord, the case has been lodged.
Why don't you bring her?
My lord?
You bring her. She has said that.
My lord, the problem is that she married elsewhere.
In her absence,
It may affect her marital status.
Someone, my lord. He might be engaged in counseling and another date might be given.
The service.
My lord,
Sufficient age.
notice sufficient. She is not turning because of she is married elsewhere and.
That reason, her sister might receive the notice. And she intimated to her sister.
Problem is these are the not 376 and all can't be caused in her absence. You are on bail.
My lord, the affidavit sworn in by her herself. My
How
lord.
do I know affidavit?
Yes, that is true, my lord.
Then it has to be tested. Bring the notary. Who appear before notary? I don't know.
That's true.
Whose signature is there? There are many questions comes there. For the bail purpose, it's all right.
Press notice again through IO.
For the bail purpose,
IO
it
दे
is-
दीजिए ना IO ने तो होनी notice दी थी outing the appearance of the operative to maybe urgent since IO went yesterday.
The last date of hearing direction was given to the IO for effecting service on the opposite party number 2. It appears the IO has heard the sister party number 2. This can't be treated to be a sufficient service in view of the fact that the present case involves offense under section 376 so and so 376 2N 376 2N petitioner to take fresh steps to serve the party. Yes. Or otherwise, what I'll do is, I'll tell you, the best course is, instead of struggling here, I will target the... Listen to me. He will not come there. You will be acquitted.
Another chance may be given to her. Otherwise, the material witness may be examined.
That's the best
Committal
way.
process is there.
That's the best way. He will be acquitted.
Yes,
He is
my lord.
settled. He will never come. He will be acquitted. Unnecessary struggling here.
One chance may be given to her. Then next.
Many chance we have given. This is the best chance I am giving you.
Then your committal process is there. Your lordship may direct that.
Since he is not cooperating and you are saying that given affidavit, everything I'll write and give a direction so that it will be easier, isn't it?
Madam, that is that.
Right on. The petitioner has filed the present petition seeking
sorry.
passing up.
My lord, he is not in bail. It may be affected. Yes. The petitioner is not in bail. The further proceeding has stayed.
Charge sheet showing absent the unnecessary appear how can they try?
My lord.
You have to
appear.
Let another date may be fixed. I will try to. Bail may face
Cognizance
another.
order on the basis of a settlement given by the victim.
Another date may.
In affidavit, no question of passing.
Another date may be fixed.
Another date, the things will be the same. Now, what is the way? I'll dispose it out. Will you appear?
Difficulty is that my lord is not on bail.
No, I'll record all this thing. You
Yes,
get
ma'am.
the bail. I'll tell you.
My lord.
You get the bail.
My lord, then it.
You get the bail. What is the problem? Write down. the cognizance order dated 10/11/2021, passed by SDJM Hindol in GR case number 452 of 2021, whereby cognizance for offence under section offence under section 320. Where is the offence?
323, 506, 341,
506, 341,
417, 376, 2N and 34.
And 34 has been taken against the petitioner. Against the petitioner. It appears the petitioner has been absconding in the present case. Absconding in the present case. The petitioner has sought quashing of the entire proceedings on the ground that where is that affidavit?
Well, that is at Annex 2.
On the ground that the petitioner has already settled the dispute with the victim. It appears the victim has given an affidavit which is placed on record. Affidavit dated 29
August 2022.
Which is placed on record, wherein the victim inter alia has stated that she had filed the affidavit due to misunderstanding. With the petition, due to intervention of the local gentry, she has already settled the dispute with the petitioner. Notices were issued to the petition victim, being opposite party number 2. However, the service could not be effected. So eventually, the IO is directed to serve the notice on the opposite party number 2, the victim. Despite the service, the victim has not appeared. Therefore, it is therefore the veracity of the affidavit placed on record by the petitioner, veracity of the affidavit by shown by the victim, respondent number 2, which is placed on record, could not be verified and could not be verified. Moreover, that can't be a ground for quashing the entire proceeding. Since the petitioner has been absconding in the present case, he has to appear before the court below to prosecute. Appear before the court below. On instruction, the petitioner submits that the petitioner is appearing before the court below on or before 31st of August 2023 and resort to remedy available under law. With this liberty, the petitioner is disposed of, and no course of action shall be taken against the petitioner till that day. And once the petitioner appears in view of the particular facts of the present case, the court below shall do well to see that the petition is the trial is concluded as expected.
Matter.
Disposed of. Yes, yes, sir.
Item 110.
110.
Can it be taken up on 21st?
110, 20.
I will intimate the other.
21st. On request of senior counsel, 21st. Yes.
All right. And the next item. Next item. 2 weeks after.
101.
Yes, ma'am.
2 weeks by?
And they have not filed the comprehensive affidavit regarding settlement, ma'am.
You have not cured the defects also.
Yes.
Many defects. 101, na?
Yes, ma'am.
Many defects.
I will.
Learned counsel for the petitioner seeks 1 week time to cure the defects pointed out by the registry. He may do so within 1 week. If defects are not cured within by 21st of this month, the petition shall stand dismissed without reference to the court.
Beggar pardon.
Defects are cured, this is the matter after.
Beggar pardon, my lord. Item 117. My lord, Mr. Das has some personal difficulties. Is not coming. Gone for medical treatment, my lord. Yes, my lord.
117. Personal difficulty.
My lord, on Wednesday.
Don't decide the date. It will go to end of September.
Patent to mention, my lord, item 118 can be taken up 2 weeks after. LCR not received.
LCR not received. LCR call for the LCR 118. Call for LCR, please. After 2 weeks. Yes.
For Lordship's permission, 104. My associate pointed out that some defects is there. If your Lordship will take up this matter, I have nothing to say. If
Defects are curable, then ignorable, then no problem. 7. Defect number 7. Kya hai?
104.
Only one defect, that is defect number 7. It is curable defect, forget it. Proceed with it.
Item number 113, kindly 2 weeks after.
We will proceed. If you have a difficulty, that is a different story. Otherwise, you can proceed.
Tomorrow?
Not tomorrow. Adjournment means according to our board, not according to you. You adjournment, that request is accepted, but the subsequent thing we will do.
But I have learned.
Yes, sir.
Lordship also in the side. Both are coins to both sides.
That's right, but see, you can't fix the date according to your choice because our boards are pick up. So you adjournment personal difficulty, no problem, but it has to come according to the schedule. Will you do it or adjourn? Will you do it? Let it be there. Okay.
Item number 113, kindly 2 weeks after. Entry matter to continue.
Entry model is there. Entry.
113 I am appearing for operation number 2 minutes. And in this case, my lord, already I have filed my power, my lord, and it is also reflected in the cause list.
Yes, yes. Tell me what you want.
Noting is there, my lord.
What do you want, sir? You want an adjournment? What are you arguing? Who is appearing for the other side? Who is appearing for the other side?
Oh, is it saying for adjournment?
Okay.
My item number 15 and 23, my lord. 1 week after.
15, 23. Weekly we'll see. Weekly.
I made a mention, my lord, also told me that it will be taken about 2 p.m.
What is this matter, Jibo?
Regarding for granting bail, my lord.
What?
Bail.
Bail matter, you should give priority. You are not coming anyway. 48, huh?
48, sir.
Yes, tell me. Custody since?
Custody, my lord, since 2022. Incident of 2016. No one has seen the occurrence. He was also not named in the FIR.
302.
Yes.
My lord, actually, though it was urgent, so this file is not available.
Urgent 2?
No, my lord also died.
So, date is short.
It was directed to be listed on last week, sir. It was directed to be listed on last week.
Since you were not there, I adjourned to September. Now I am preponing it to next week.
My lord.
Yes, next week.
May I please, my lord?
Next.
Mention 57 item.
My lord.
57. Yes. What happened? 57. What did I do? I have passed some orders.
My lord, I have not moved. It has passed over. It is added matter.
No, there are connected matters I have heard. Somehow I passed, maybe.
My lord, I am in different footing. I am in different footing, my lord.
If you were not there, what to do? I can't keep on recalling. The orders are already typed and all. We'll see what happens. Yes. Next.
51. 51, my lord, kindly adjourn to 1 week after.
Urgent?
Yes, my lord.
Bail matter? Huh? That is in September.
62.
62. Yes.
Case of
Yes.
Right, it's a case of 376. Sorry, 354 A, 54 D, 376 2N, 506, and 6 of POCSO Act,
Yes.
read with section 66 E
You are-
and 67.
You are 27 years. And
My lord,
C is
My
the
lord,
C-
my lord, here is a case as per the
two things must be there. One is the POCSO, another is viral.
viral. My lord, I have this case was urgent today to verify whether the victim has been examined or not.
Yes.
Yes, but the trial has already been examined as PW4.
You have the statement?
My lord.
Yes. The six. Yes.
My lord, considering the statement of the victim,
PW?
there is the PW4, my lord.
4 years.
Paragraph 14. My lord, you will see. My lord was pleased to hear me on the last date, wherein she has categorically stated that they had relationship for 7 years since 2017 till she denied to marry the petitioner. And it is alleged that in the year 2022, the photographs were made viral, and she could know it in the month of December for 23, for which she has filed the case. And on the perusal of the seizure list, and also, my lord, the statement, her statement, that during the investigation,
Have you circulated or you are threatened to circulate?
Yes, but nothing has been circulated. Photographs has been seized from her mobile. I'm coming on, my lord. Photographs are definitely, my lord, nude photographs, but it has not been seized out from outside or not or from my mobile. It has been seized, my lord, as per the seizure list. My lord must have got the seizure list. My lord, may see seizure list 345. 345. After that, my lord, seizure list
3, 4?
3, 4, and 5. My
Yes.
lord.
Copy of a screenshot.
My lord.
Of Ali's photo so in serial number. Whose mobile?
Her mobile. Her mobile, my lord, that high-tech, my lord, may see how she has stored it.
One high-speed mobile.
Yes.
Micro memory.
That I do not, I
Hard
have not yet understood what is
contained
high speed.
The viral photo. No, it is in whose mobile? In her
Her
mobile or in
mobile.
his mobile?
Her mobile. No, my lord. He's not his mobile. I have verified
4 postcard
before
size
my
photograph.
submission. Yes.
4 lines from 164 state from the victim.
My lord, may see that.
Photo viral करदो बोली कहला मोर Instagram ID को
नहीं see I
ID ये सब घटना विषय रे मेसेज आतिला तू मोर पूछी घर को मु मो पूछी घर पळई एबे 7-8 दिन ला जाने पाई फोटो वीडियो फोन साइट व्हाट्सएप आदि सोशल मीडिया रे अपलोड होई भाइरल.
but whether see there is no face in that photograph. There is no photo face. Some other photograph is faced and this girl's photo is at the end. What kind of investigation? What kind of investigation?
After rejection Miller, thereafter charge sheet filed.
Why don't you go to trial court? This materials are there and record everything. Go to trial court. That's better idea. Give me.
In the meantime,
Give me that.
Abstain.
Right on. Petitioner is agreed by the order dated 15/2/2024, whereby the application for grant of bail has been rejected. Subsequently, thereto, the trial court has recorded the evidence of
PW4. She has been examined as PW on 20. Exact date. But 24/6/2024.
24/6/2024. Mr. Dhawal, counsel for the senior counsel for the petitioner, submits that there are three seizure articles, number 2, 3, 4, and 5. All these seized photographs and the mobile phone belongs to the victim herself. So she is a party to the recording of the alleged nude and obscene photographs. And I have also seen the document placed before this court through the legal counsel for the state regarding the nude photographs. And it appears on the photograph that the girl's face is not even mocked. Rather, the victim's photograph is affixed along with certain nude photographs, where his face is also not, face of the person whose photograph is affixed along with the petitioner, along with the victim, is also not revealing. Be that as it may, the fact remains that the victim has already been examined by the trial court, and the bail plea of the petitioner was rejected much prior to that. Therefore, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to approach the trial court renewing the bail. If such application is made, the same shall be considered on the basis of material available. With this observation. Yes.
68.
Sorry?
823, 304, 306, 34.
Poison.
Statement of the information
CD is there.
Charge sheet is.
Huh?
Charge sheet is literally.
Charge sheet when filed? Charge sheet is not yet. But investigation is still going on. 304. Huh?
Left charge.
Investigation is still going on. In 2 weeks. And counsel for the state submits that the investigation in the present case is still going on. Charge sheet has not yet been filed. At least the matter of 2 weeks. Charge sheet. Yes.
73.
Now he is giving a date.
73.
73. Bail. Offense. 376 again. Foxo. Urgent for 2 weeks. Non-appear for petitioner in the interest of the urgent. Yes.
84.
May I please?
Yes.
Here the present petitioner has approached the court after filing of charge sheet and his prayer for bail being rejected by the court below, and he has approached the court in custody from 59/2023.
59?
2023, my lord.
My lord, here, my lord, that they are petitioner and the deceased, they are belongs to one family members. Due to their dispute relating to share in the ancestral property, they have assaulted, and my lord, the HR PM report is that, my lord, there is a manual strangulation. This present petitioner role is that he, along with another person, Maheshwar, they have taken the deceased from their house. The mother has given the affair and he has seen that is the last in theory. where there is some other material witnesses, whether they are present at the time of that occurrence. But the 161 statement, my lord, is totally not legible. So I pray, my lord, 2 weeks time may be given that I will obtain that 161 other materials. My lord. They have sent, but it is not legible.
So go to next page also.
But
But you find out how, see, you might have supplied the copy also. Supplied a copy to the charge sheet has been filed. You might have supplied the copy of the charge sheet.
He's saying that the copy which he has received.
And that's what I'm asking. You might have supplied. You would be having that. Please just see whether you have legible copy of it. If you have the copy, please give him so that. And if he asks to the police, again they'll send the same kind of. If you have a better copy, give him so that.
Yes, better. Only that person I will check out whether.
Please give it.
And one captain.
Yes.
96.
Yes. Verification. Yes.
My lordship directed.
His mother expired.
Lordship directed to take instruction. Though offense was committed in Telkoi PS case number, Telkoi PS in the district of Keonjhar, but the present petitioner, his residence is Hon'Ble under the Pallohara police station. So directly I have taken instruction from the police. That is on oral instruction, my lord. He has not supplied the written instruction because
it's all right. What
she has died. Died, but oral instruction I have taken, my lord. That on telephone, over telephone, he stated.
Mother died. He is the only son. Only son?
No,
anyway, son. Is it younger son or elder son? Younger. Mother died.
Yes, so lordship may grant him bail. Only that your lordship will reflect that.
15 days and you have to surrender and then again we will decide your bail.
Only oral instruction I have submitting. That your
Where
lordship.
is that certificate? The petitioner is accused and so on so. And that will be clear. Anyway, IA recall though. IA 992 na? 992. Petitioner has moved an application for grant of interim bail. Interim bail for a period of, you ask for how much? Interim bail. On the ground that the mother of the petitioner has expired on 5/8/2024. He has placed on record this certificate issued by the Panchayat Samiti Pallohara. This court has, in the first hour, the court has asked the state council to verify regarding the factum of death for the mother of the petitioner. Mr. Mishra submits that he got oral instruction confirming the fact that the mother of the petitioner has expired on 5/8/2024. In order to participate in the rituals, the petitioner is enlarged on bail for a period of 15 days, entry bail for a period of 15 days. 15 days. 15 days count karo to today is 12th. 30th karo 30th. For a entry period till 30th of August. And the petitioner shall surrender before the court on 31st August at 10:30. Surrender before the jail authority. Jail authority on 31st also and submit a report. Release the matter on 2nd. 2nd September. 2nd September. Order in court. Order to release in the court service. फटाफट क्या कर दो दे दो बारी है ना बारी. And you collect it. Collect in between. Corriging दो मुझे sign कर दो. 99. Just now he is giving. I'll sign here itself so that at least today you can come out.
Your last time I had prayed for time, my lord. on the ground of how to get a copy. Today I have got the copy, my lord.
99.
I'll file it by Friday. I'll take it on Monday.
Mr. Chand, Land Counsel for the petitioner, seeks 1 week time to file the
Certified copy, I will order.
certified copy of the documents. He may file the list it after 1 week. Yes. 99. Item 99. Yes.
102.
102 withdraw. 102 withdraw. Remove one day. Yes.
103.
103. Yes.
In this matter, I have filed
102,
the
your lordship, I may be
number
permitted
mentioned.
to
For that
withdraw.
reason, I want to take
102, your lordship, I may be permitted to withdraw.
Yes, yes, done. Done.
Obliged.
I may be permitted to take notice again, your lordship.
What? Why?
Because I have filed requisite, but the wrong mentioned the wrong number.
Land Counsel for the petitioner submits that he has although filed the requisite, but he has mentioned inadvertently he has written wrong number. He may take the first step for the proper approval.
Within 3 days.
Within 3 days.
Published.
Yes. Yes. 104. Yes, Mr. Das. Yes.
This case where the victim lady, the conduct of the victim lady, how it can be evident from my lord. For
You are seeking quashing?
my lord.
What victim lady? Foxo is that? What?
No, that is there, my lord. Then your lord, prior to this, my lord,
Don't say lady.
Your lordship come to
She
pay.
is a minor girl.
Minor girl. That is a story has been created at the age of 20. She lost the affair. Prior to this case, my lord, your lordship come to phase 28 of my brief.
When the incident taken place, she was minor.
No, she has narrated. The cause of action arose where the affair has been lost. Prior to coming to this case, my lord, your lordship come to page 28 of my annex 3 of my brief.
28, huh?
My lord.
Yes.
What is the allegation? 376, 313, same allegation. 494 against another person. 5 cases has been instituted. I have collected 2 cases. This is the conduct of the victim. Extracting the money and thereafter compromise. 1 case, she has succeeded, married to the person concerned. In another case,
what you are trying to say is she has filed similar cases
against
5 people.
1 person to another, another person to another, including 5 persons, they have been victimized.
Yes.
In such case.
And he says that 5 cases were filed, he could successfully marry with 1.
One, my lord.
And other 4 matter, he had taken money.
And the 2 to 3 cases are there. Charge sheet there.
Whatever charge sheet, if this is the conduct, I'll quash it. You can't allow the system to, take in ransom by this kind of character. You verify it and tell me.
I verify another thing. 373 notice is mandatory.
3 notice actually. Yes, issue notice to opposite party. Yeah, opposite party number 2 to be served within a week. Within a week, requested to be filed within 2 days. Land Counsel for the state and learned Mr. Das, Land Counsel for the petitioner submits that the same alleged victim has filed as many as 5 cases against different persons alleging this exactly the same making exactly the same allegation. He could only collect 2 FIRs. 2 FIRs. Counsel for the state is directed to obtain instruction regarding the number of cases the victim has filed against the individual, any individuals, and the status of those cases. Leave the matter after 1 week. Please after 1 week.
105.
I have filed an IA, my lord.
IA for what?
No course of action.
Anticipatory bail you have not filed?
No course of action because
in view of the peculiarity of the present case, no course of action shall be taken against the petitioner till the next date of hearing.
Obliged.
Yes. This is a peculiar case that I am giving. This is a you can't take.
Let him take it.
You take instruction. If she has done it, then yes.
Due apology, your lordship. 73 hanged over in court number 6. That is why I become late.
73 I passed some out, right?
Yes, your lordship. To next week and non-appearance.
Non-appearance colony. Now in the bail matter, I am not in bail matter unless I say non-appeal. The name of the lawyer must be written.
Lordship, next week, your lordship is
Yes.
obliged.
105.
I may be pardon your lordship.
Yes.
Last occasion I could not appear before this court on that case due to ill health, your lordship. But your lordship, in last occasion, your lordship is directed to state the obtained instruction regarding the status of the case.
Status of the case. What is the status? Have you got it? What is it?
Status of the action yet.
In the last date of hearing, State Counsel was directed to obtain instructions regarding the status of the present case. He is awaiting instruction. It will be matter after 1 week. Yes.
106.
Published.
1 week after.
1 week after. Yes. 26.
Stay of a conviction.
No stay of conviction. Argue the matter. Argue the matter if you are ready. I'll hear it. Huh? The matter is ready for hearing. List it in the weekly. Huh? This is weekly? List weekly. Weekly, we'll see.
107.
And no, Mr. Rizvi, you were waiting for some certain matter. 120. No, you tell from 1. Item 1. Come to item 1 because he met with an accident. He is not well. He'll come for these matters. We'll make him free. Yes.
Item 1.
Yes.
Call for instruction 32 matters.
32 matters.
25 matters. Inspection. The rest matters like 7 or 8 matters. Your lordship can-
The matters where you have not got instruction, give the numbers, and that will I'll put it 27. Okay. The matter where you got the instruction that the appellants have died. Okay, run the list. Okay. 1. Elite, no? Yes. Who died on? Who has said that? SP Sambalpur, Vigilance SP Sambalpur has informed pursuant to the direction dated 29/7/2024 that the sole appellant has expired. Therefore, the appeal stands abated. Next. 3. Yes. 27. Yes. 5 said 27. Yes. Is it alive? Or let it be on the weekly list. We'll see. Yes. Yes. 6. 8. What about 6, 7? Yes, yes. 6, 7 also will lie over. Okay.
He died on 28/10/16.
28/10/16. SP Barampur has been informed pursuant to the direction of this court that the sole appellant has died. Therefore, the appeal stands abated. Yes.
Item 9 died.
Yes.
Item 10 may be taken up on 27.
27. Yes.
11 fellows is alive.
Alive.
Yes.
11 alive. Remain in the board. Yes.
Also alive.
Yes. Alive.
13 also alive.
Yes.
13
Alive.
also alive.
Alive. Yes.
As far as
Therefore, in 14 there are 4 matters. All of them are.
Yes.
Still.
We have got instruction 156 of 2000 Purna. He is alive. So for Madhusudan is concerned matters, it may be taken up to 27.
27. This item 14, 27. Yes.
15 matters he died.
Died petition. When?
17.
2017 died. Barampur. If you Barampur. Stands abated. Yes. Yes.
18 also is remaining.
17 somebody appeared. 18?
18 also is remaining in the board.
Okay, remain in the board. Yes.
19 matters which have not been we got instruction.
Mm.
It's not raised. In fact, we also consider that one. He also was not able to say anything. You can take another chance and call it
Okay.
27.
27. Okay.
20 matters he is alive.
20 alive. Yes.
21 also matters. There is no documentary evidence, but there was local inquiry conducted. Nobody was able to say anything. but we contacted the staff and he was working last. So they said that he has died.
Okay.
There is no documentation.
The SP SP Barampur from inquiry came to know that the sole appellant has died. Therefore, the appeal stands evident. Yes.
22 is eligible.
Yeah, like yes.
23 also eligible.
Yes.
24 and 25 will be taken up on 27.
27.
26 he died. He died on 4/12/2009.
4/12/2009.
I may be, I may be permitted. In item 22, I have filed my wakalatnama yesterday. My name of Mr. Vishnu Prasad Pradhan may be reflected as appellant counsel.
The name of Vishnu Pradhan reflected in item 22. Yes. 28 we are there. 27. Okay. 27 will be on 27. Yes.
28 is eligible.
Yes. 28 there are two matters. Okay. 27. Yes. 29. Yes. 27. Yes. 31 you are appeal. Okay. 11.
Yes.
There are two both of them are living. You.
No, Gauranath Das, for Gauranath Das.
You are appearing?
I am for the Gauranath Das, my lord.
Somebody pay, okay.
And 35 will be taken up on 27.
Okay.
32.
36 alive. Yes.
37 is alive.
37 alive.
38 also alive.
Yes.
39 also alive.
Yes.
40 also alive.
Yes.
41 may be taken up on 27.
27. This is what it is position. Okay. At 27th, I am still waiting 7 to 8 matters.
That process will complete the exercise of getting the whereabouts. Only 7 matters pending.
Okay. Today, how many matters got abated? Roughly about? Five, 6 matters. 5 minutes. Okay. Get instructions.
5 criminal appeals have received the instructions. Yet none of the appellants are available. So this can be disposed of. 5 matters.
Release it tomorrow.
I have given the credentials also when he died and who was the SP counsel.
Release it tomorrow. We will dispose of all the files.
I am one of the appellant in item number 28, Miller. And
28.
Yes, Miller.
28.
It
What
has
did I
been
do? 28. Just see what.
20.
Yes. You are for?
I am for Boston Swine, the first one.
First one.
Yes.
Alive?
Yes.
Yes. Jharna Ghosh has died.
No, I am not for Jarna.
Jharna Ghosh has died. Yes.
No. Information is.
Instruction awaited.
Yes.
Okay.
It's
Please, these 5 matters. Okay. You may leave because you are not well.
so my matter will be taken on 27, Miller.
Yes, today I can't take because he made
Yes.
an accident. Yes.
Always.
Yes. All.
Pattern will taken today.
I don't 31. 31. I'll take it up in a later date because he is not well. Today he is not ready. Yes, next. 107. 107. Adjournment. 108. 108. Yes.
My lord.
Yes, sir.
108.
Here.
An FIR was lodged against this present petitioner. And FIR, my lords, under section 420 and other allied sections. Now this FIR ended up in a charge sheet. He was exonerated from the charge sheet. Now the same person again initiates a complaint case. He doesn't challenge that charge
No,
sheet.
has he filed a probate petition or what? Protest
The
petition?
protest, nothing. This is a separate proceeding. He again files a complaint case and again proceedings, and the magistrate takes under 202, he says, refers it to first, sorry, he first refers it to the under 156, he refers it to the concerned police station, which happens to be the same police station. And against my lord's proceedings are being have been initiated against him, and charge sheet is being filed again. So if he would have protested against that charge sheet, then I understand.
Yes, Mr. Ragada, who is appearing?
Your lordships,
how do you address this issue?
Your lordships,
see, what had happened is a FIR was filed, investigation taken place, and a closure report was filed. The option for the complainant is to file a protest petition. He did not do that. He initiated a 156(3), where a direction was made again, same allegation, and the police now investigate and file a charge sheet. It is virtually second FIR on the same thing. Then it has to go.
No, what I'm submitting, my lord. One passage is file has been allotted to Mr. Ragada, my lord. So what instruction he has taken, I have not known.
Because your lordship had also formulated a question. Just by order dated, order number 2 dated 18/4/22.
2, huh?
Yes.
Yes.
This matter on 11 July was as prayed for by learned ASC to take instruction and to file a reply as to whether the present complainant was also one of the complainants in the earlier case.
Yes.
This is the
crux
question.
Of these.
Mala?
This is the crux.
This is the crux.
You have to address it, sir.
One pass out.
No, I am adjourning it. Entry order to continue, adjourn it to next week. Yes.
Obliged.
109. 109.
May I please?
What is this matter, ma'am?
Sure.
How many matters you have filed?
There are 7 checks, so 6 matters have been filed. In respect of the last check, one GR case has been initiated, Your Lordship. There are 7 checks. This is arising out of a 138 application, Your Lordship.
138?
Yes, Your Lordship.
You have issued 7 checks.
I was allegedly issued 7 checks, yes. Allegedly, Your Lordship. The fact
that is what is trial court has to decide.
Yes, Your Lordship. Yes, Your Lordship.
Whether it is allegedly or it is whatever.
Your Lordship, yes, Your Lordship. I have filed this application, CRLMC, challenging the order at Annexure
What are
7.
the checks, amount checks in all the matters?
The checks are allegedly of 25 lakh each, which is not true. Your Lordship, kindly bear me for a minute. This application I have filed and assailing the order 11/3/2022 at Annexure 7. 11/3/2022.
Yes.
By which the learned trial court rejected my application for issuing summon to one defense witness, Your Lordship, to whom I want to adduce in my favor, to whom I have actually paid some amount through which they say that for which I have issued my checks.
In all these matters, what are the issues? First one is
Should I kindly say, in 2015, the petitioner and the opposite party came to know each other, and accordingly, and the opposite party is a private money lender, and I got a hand loan of 38 lakhs for my business, for expansion of my business. By 2017, I repaid the entire amount. It was agreed between the party that though I have received 38 lakhs, I have to pay 40 lakhs as repayment. I paid the entire 40 lakhs. Then the opposite party said that you pay additional 7 lakhs, which I said I need some time for arrangement. In the meanwhile, the opposite party said why money compelled me to issue checks to secure that 7 lakhs.
How many checks?
7 checks, Your Lordship, for
20
1 lakh
lakhs
each. Yes.
1 lakh each.
1 lakh. It was supposed to be 1 lakh each, Your Lordship. They just compelled.
What is the check amount? You tell me 1 lakh.
25 lakh.
Each check 1.
Yes, Your Lordship. They put that amount in. They put that amount.
Has he issued statutory notice to you?
Yes, that
You
notice
received
was issued. I did not reply, Your Lordship. That was my fault because I was
Then you have to face it. Presumption operates against.
Your Lordship.
No, I can't interfere. This is 138 case. Presumption operates against you. 138 notice was given to you. You have not answered.
Your Lordship.
And then you got to face the trial and get yourself out.
Yes, sir.
That's the law. What to do?
Yes, I'm facing, Your Lordship. Now I am like, if someone may be issued by the court, to adduce evidence to examine Nidhi Vora, to whom I have paid the substantial amount around
He is
29
your
lakhs.
defense
Yes, Your Lordship. That is my sole contention.
Yes, in all the matters.
In all the matters.
How can
These
you
are
prevent?
connected.
How can you prevent
It's
examination
not
of?
of preventing anyone, Lordship. The alleged transactions, he says Niti Bohra, two parts submission, my lord.
Whatever you
My lord,
see,
if
if
that
he
one-
wants to examine, how can you stop?
Lordship, really. Allegedly, that amount was paid in 2016.
Do I need to go to all these?
Yes, these checks were issued in 2018.
You tell me he is an accused or he is an accused. Being an accused, he has a right to defend himself.
Much
Yes.
obliged.
No denial of that.
He wants to. I'll give one opportunity. Let him come and finish it up.
Yes, sir.
Why
Much obliged.
unnecessary?
Much
Your
obliged.
Lordship is not, I'm sorry, I won't take your Lordship to look at the things from my point of view. My lord, the allegation of the 17 lakhs transaction to Niti Vora in one case, that is one thing. All the 7 cases. Now, my lord, that was in 2016. Allegedly, it is paid in 2016. Her client has paid to Niti Vora, who stays in Canada or somewhere. My lord, allegedly, she is my niece. Now, this agreement or these checks have been issued on December 2018. Much after that transaction, even if it is true.
You can't you put all this thing to the witness who is coming?
That is what the trial court has said. Your Lordship,
Show me the impugn order. You can put all these things to the
Lordship,
witness.
kindly, imperial page 27.
Your Lordship, look at the trial court's order.
It starts with page 28. Kindly see.
Page 20.
Page 28, Your Lordship.
Okay.
It starts
Read
with
the
page
impugn
20.
order.
Lordship. Court peruse the record. The accused person wants to examine Nidhi Vora, the niece of the complainant, on the pretext that he had paid huge sum of amount to her as per the instruction of the complainant, in support of which he had filed his bank statement, as well as WhatsApp communication between Nidhi Vora as well as the complainant. Regarding the WhatsApp communication submitted by the accused, it is worth mentioning here that it is inadmissible as evidence under Section 65B of the Indian Evidence Act. On the other hand, the complainant objected the petition and averred that this is the delaying tactics of the accused. The payment which the accused person claims to have been made the niece to the complainant was made in the year 2016, while the agreement for the clearance of the check as marked as exhibit so-and-so by the prosecution was entered into the last month of year 2017. After hearing both the parties' perusal of the record, I am of the view that the bank statement submitted by the accused person is not sufficient ground to summon Nidhi Vora and adduce evidence. Hence, I am not inclined to allow this petition to summon Nidhi Vora for defense.
Your Lordship has seen it. Checks were issued in 2018.
I'll only place 2 judgments, Your Lordship.
According to me, this order is wrong.
Your Lordship may look at what's the
Now, what was the necessity to say this is admissible or it is not admissible?
But
It was not called on.
It is on merit, Your Lordship.
Then you are see WhatsApp messages. She can rely upon those WhatsApp messages. 65 affidavit she can give.
Anyway, Your Lordship may look at the WhatsApp message.
Why should I go into all these things?
That's what I am saying, my lord. Your Lordship need not go at all.
So therefore, I am saying I'll give only one opportunity to her.
Simple thing. My
She is entitled to lead her defense evidence.
But to what? With regards to the checks?
To the payment. To the payment.
Wait. Checks were issued in 2018.
No, that's not the test, sir. You know,
the test,
it
sir.
is the rebuttable presumption.
She may kindly
Drawn against her. The rebuttable presumption, she has a right to rebut. How can you stop it?
She may kindly see page.
With the bona fide intention. My lord, alleged transaction is 2016. This payment.
Okay, all these matters, the same order?
Yes, sir.
Same
order, but one payment. Same order, but one payment.
Okay, I'll pass the order.
I
I'll pass the order. I understood it. Now.
May I be permitted to file certain judgments, Your Lordship?
I'll rest.
All the matters pending.
I may be permitted.
I will record.
I may be permitted to
This may be-
rely upon certain judgments, Your Lordship.
This may be also seen. My submission. Your Lordship, 2 documents. Your Lordship, since your Lordship pass an order, my lord may look at 2 documents.
Yes.
Page 14.
14.
14.
1-4.
14 is the alleged transaction, 15 July 2016 at the top. Nidhi Vora. Upon our page, Monsieur Guinness, scanning page, I don't know.
Is there?
15/7/2016.
I hope Dolly Mausi spoke to you about
Dolly
my
Mausi
fee.
is the opposite party, Sweta Parikh, Your Lordship.
And can you transfer the fee to my account.
Yes.
Like you did that.
She has possibly paid it. She has possibly paid it in 2016.
But that is for towards something else, you see.
I said that has been taken into account in the checks. Your Lordship are now trying to pay.
So those things you have to put to that witness.
Why should I, Your Lordship? Why should I, my Lord? Private basis has to establish. Your Lordship,
You,
now-
that is their problem, whether why should you
Now,
put or
now,
why should
now,
not
now,
put.
now,
You
Lord,
can't
now-
prevent that witness to come to the witness box.
My Lord,
Because he is in a trouble in the sense,
kindly bear with me. Kindly bear with me.
presumption operates
Your
against
Lordship,
him
Your Lordship,
and
I'll
is
be
a rebuttable
consulted.
presumption.
Your Lordship, my next turn to page 20.
Yes.
This case relates to, my Lord, paragraph F.
The best thing is that you know that you have a difficult case till you are arguing.
Which one is difficult?
It's very difficult.
My Lord, I say this court is interfering, but it should, ought to. Maybe that is the effect of daily practice. Accordingly, on 18/2017, third line,
Right.
next area, the accused executed a receipt acknowledging liability and also handed over 6 number of post-dated checks that were 25 lakhs each. And this first check is 592 relates to this case.
I am sure that she is going to be convicted.
I am not on that at least not.
But what
Your
you-
Lordship should pass an order which should not satisfy me, should satisfy your Lordship's conscience. That a check is being issued on 18/2018. She is alleging a transaction which appeared in 2016. How this payment could be related to this check? This is long submission. This Lordship may record and pass whatever.
What-
order.
I have
how much
filed-
you owe, by the way? How much you owe?
2
No, no,
crores
I-
here. 2 crores here.
According to them, I took a loan for 38
Now, how
lakhs.
much you owe, you tell me. 25 lakhs?
7 lakhs, Your Lordship.
7 lakhs.
7 lakhs.
According to
Your
you,
Lordship.
7 lakhs.
7 lakhs. Your
According to them, 2 crores.
This is
25 lakhs is his check.
This
Lordship. Yes, Your
exhibit
Lordship.
six.
For each lakh.
No, check.
Your Lordship, may I kindly see section
25?
243.
Each 25 last is 55 lakhs.
There are 7 checks. He says I took 1.55 CR for a purchase of a house, Your Lordship. I was supposed to sell my house to her client, Your Lordship. There is no receipt. There is no money receipt. There is no agreement, and she says that she has paid me the entire amount.
Before part of the case, one of the part of the record, this is exhibit 6, the court has referred to in the appeal order. This my lords may look at.
Exhibit 6 is a self-serving document which I'm admitted to the under compulsion. I must have signed it. But that doesn't debar the court from adducing me defense like.
In the regional court of your lordship to interfere, maybe. He says that he has received the checks. Sorry, issued the checks.
May I read
This
two?
is the date. This has already been exhibited.
Yes, sir.
Exhibit 6.
That's what I'm saying. She is bound to be convicted. He is bound to be convicted.
I may be, at least I may be
Bound to be convicted.
section 243 may be given a
For-
to your lordship.
for judgment which he is doing.
Like, I'm relying upon the judgment which is based upon the section 243 of the CRPC, which says
Should I file this?
evidence of defense.
Why to complicate?
Lordship, may I read?
Keep it simple.
Indicated in the order.
May I read the section 243 for a moment?
Yes.
Here? 243. 243(2) is the relevant for the lordship. If the accused, after he has entered upon evidence, applies to the magistrate to issue any process for compelling attendance of any witness for the purpose of examination or cross-examination, or the production of any document or the thing, the magistrate shall issue such process unless he considers that such application should be refused on the ground it is made for the purpose of vexation or delay or defending the end of justice, and such ground shall be recorded by in writing, which is not the case at hand. This is the first time I wanted to adduce any evidence, and I filed an application which was rejected. And I've, Lordship, may I be permitted to place this judgment, Sir Lordship?
Yes. Which para?
Lordship, citation document.
Which para you are reading?
Lordship, first I will 2008 5 SCC.
Yes, I'm there.
2000 paragraph
Guwahati, you are
8,
reading
9, and
Guwahati.
11.
You are reading Guwahati? No.
No, Your Lordship, this is 2008 5 SSC 633 T Nagappa versus Y.R. Muralidhar. Yes, sir.
T Nagappa.
Yes, Lordship. The third
Yes,
judgment.
third
Yes,
judgment,
Lordship.
yes.
So, I'm relying upon page paragraph 8, 9, and 11. Your Lordship. May I be permitted?
What is this practice of not giving the bunch without pagination? Yes.
Oh,
Which para?
Your Lordship, I may be,
Which para?
Lordship, I may be permitted to replace those judgments, Your Lordship. That was meant for me. I have erroneously given it to the court.
Yes. Which para?
Para 8, 9, and 11, Your Lordship.
8 and
8,
11.
9, and 11, Your
Yes.
Lordship.
Yes.
Okay, I mean.
Again, 143 elaborated.
Yeah, this is regarding the 243, my right of adducing evidence. Para 9, Your Lordship.
Where is the quarrel on this legal proposition?
Lordship,
no
that is
quarrel.
the quarrel, Lordship. Your Lordship, the learned lower court has rejected, Your Lordship, without discussing anything.
And
Your
where is
Lordship.
that, this 2000 para 9? Para 9, what is it?
2009. No, Your Lordship, there are 3 judgments. One of 2008, Your Lordship.
Then warrant tribal.
All
And cases are
all the cases are relating to 138 NI Act, Your Lordship.
all these cases.
All these cases, Your Lordship.
Yes. And Guwahati also. Huh? Okay, I understand. Yes. No.
The entire case is that I may
I
be permitted.
understood. I understood.
Much obliged. Much obliged.
Next.
If Your Lordship wants, I can give a written notice of submission if Your Lordship wants.
Give it. Yes.
Much obliged.
The section says unless the court finds it is vexatious or to delay the trial. If Your Lordship says the transaction taking place in 2016 has not been taken account in 2018 while issuing the checks and confirming in Exhibit 6, I got nothing for this.
Exhibit 6 is telltale.
6 is, yes.
Telltale. Yeah. But this is, Exhibit 6 is only 5 lakhs.
No.
25 lakhs also.
No,
Yes.
6 checks.
It says 6.
6 checks, 25 each. That's why I'm saying Your Lordship.
It is as if
have you placed that on
entire.
record?
There is the law. It is served on them.
You please file with a small written note by tomorrow. If you delayed, then I will not take.
Along with this.
Small note by tomorrow.
By tomorrow.
Yes.
Item 111.
Last night I made a submission with regard to compromise of the dispute between the brothers.
All the cases.
All the cases.
One payment of the
There was a stay.
stay.
I'll vacate you. You should be happy. I am vacating you. I'll disposing of all the 8, 9 cases by tomorrow.
Now, Lordship, I made 1 million. One transaction, 17 lakhs. Minimum check amount is 5 lakhs in one and 25 in each. And all the 6
I
cases-
don't think I need to go in all these
No,
issues.
all the 6 cases, 7 cases.
I'll dispose it up by tomorrow. If you don't give by morning by 10:30, I will dispose it.
No.
I'll be giving the written note by tomorrow.
Tomorrow morning by 10:30. Yes. I can't wait beyond that. Yes. Yes.
But I made a statement last night. That's the matter.
Correction to me. Just take it up here. Maybe I can't do it here. काकू देखिए दियो काकू हमरो अरे फॉलो को भी देखिए दियो भाई there is no ego in this somebody is God no है ना देखिए करो करेक्शन तो करेक्ट करिए नहीं आएगा yes sir.
But I made a statement last night that Matthew said between the two brothers. My learned friend wanted time to take instruction on that. I believe my learned friend's client has given a negative instruction.
Not settled.
No, there has been no compromise between the parties. So far as the civil dispute is concerned, relating to partition of a suit, there has been compromise. But so far as criminal proceeding is concerned, which has resulted in filing the petition.
But you are brothers.
We are brothers.
What kind of settlement? Civil case I'll settle, criminal case I'll not settle. This is very unfair. You settle it. If civil case is settled, you should settle this matter also.
My lord, so far as the instruction received.
Forget about instruction. You have to persuade.
Again.
You can't have both. You have the cake and eat it also.
Respect to my learned friend's submission. Lordship would kindly see page 18.
I'll send it to mediation. You sort it out.
Not required, no mediation required. Let's say see page 18, just by virtue of which.
No, what will happen is, I'll tell you, Mr. Otho, I can quash it on merit, no
Yes,
problem.
yes.
Once I quash it in merit, the civil matter which is already settled, there will be another problem.
Everything is settled. Kindly see the document. That's what I am trying to bring to my lord's notice.
Show me.
Yes, kindly see page 18.
1818.
Flag C. That very compromised document.
Flag C.
Flag C. Yes, my lord. That starts from flag C. Annexure 8 starts from page 17. There was a criminal case. There was a civil suit between these brothers and other family members.
Now, compromise petition. Yes,
sir. Page 17. It is civil court file.
So what is that? Where is that?
Kindly see relevant part is page 18, para Roman 6. The plaintiff has agreed to withdraw the revision. Criminal case filed before the Honorable High Court means criminal mistake. Defendant number 2 simultaneously has agreed means my learned friend's client not to proceed with criminal city number 297921 in the court of SGM Jharsuguda. So on the basis of this document, kindly, Lord, on the basis of this document, civil suit is compromised. Look at the compromise order.
Exactly.
So how can you?
What is this?
My lord,
Your client is very unfair.
my lord, whether he
Your client is very, very unfair.
My lord, only I apprise your lordship. The instruction I received from my client.
You say that you tell your client that the instruction which you are giving is contrary to the document you have signed. He is taking the courts. He can't take the court to a ride like this.
No, decree passed relating to civil.
But why has he written that criminal proceeding will also be stopped? What is this?
Yes.
That may be the reason he might have entered into the compromise.
Yes.
Because my criminal case will be over.
Yes.
If you are not doing it, then why should he go for settlement at all?
May I submit, my lord?
Yes.
My lord, this matter may be sent to the civil court.
No.
Criminal court. Criminal court. Sorry, my lord. Criminal court with the observation. With the such observation, my lord.
I see these kind of unscrupulous litigants has to be taken care of.
They will take opportunity of that.
You filed a affidavit before the civil court saying that we have settled the entire dispute, including the criminal proceeding, and on that basis the decree was passed. And today, when criminal case passing is there, you say that I will not done it.
My lord,
by taking advantage of that.
My lord, my client may be given an opportunity to file an affidavit that.
What affidavit? The civil court decree is there. What affidavit you will file?
No, so far as this compromise petition relating to civil suit, he has put his signature. I have seen, I have gone through, my lord.
And in the civil suit only this affidavit is filed. Compromise.
Compromise.
He is reading page 18. He is reading from the affidavit compromise petition filed before the civil court, where you have written that the criminal case will also be not pressed.
My lord, who has filed? My lord, who has filed?
Are you doubting this compromise itself? Then the decree has to go.
Yes.
If you are doubting this.
No, I don't have any doubt, my lord. I don't have any doubt.
Your client, I am talking. I
don't have any doubt.
Client also has
Tell him.
no doubt. He wants to.
Tell him day after tomorrow I will pass it on.
Day after tomorrow, my lord.
Day after tomorrow. Because you are appearing, therefore. Otherwise, I would have done it.
Day after tomorrow, my lord.
Day after tomorrow, you just tell him that this is not done.
May I submit?
This compromise are misleading then.
My lord, the informant who has been included as opposite party number 2, CRLMC number, he may be directed to appear before the honorable court, my lord, on that day.
Sir, you are appearing. Why should you go wrong? You seek tell instruction. Why to precipitate? Brothers. Ultimately, they are brothers, bringing to the court and all.
Brothers, but they are not pulling well, man.
Now,
they are not pulling well.
Ask him. Day after tomorrow, the court was of this view that otherwise, see, court is not powerless. Will not only quash it, I can give a direction for perjury also. That also can be done. I am not doing it, but that can also be done. You can't take judicial proceeding like this.
To initiate 340 proceeding.
340 proceeding, you have misled the court,
False affidavit.
took the degree. Today you are coming forward and say that no, I will not.
No, I am not misleading. I am not misleading.
You mean obviously not you.
No, he is my friend, my lord. He knows me. I know him, my lord.
No, nobody here will tell anything against you, and everybody learns from you, from your. But you can, since you are appearing, therefore I am putting it day after, because you have the capability to persuade your.
I think authorizing my lord is attorney has not.
No, sit down. No.
Day after.
Case, paisa kona achi.
Day after, you please tell.
You are aware.
I'll rely upon that settlement, I'll quash it.
Yes.
And I may make some observation if we play a trick with the court. Tell him, I may make some observation while quashing, because he is playing trick with the court.
In the beginning of my submission, my lord, I will pray your lordship quash with observation, my lord.
But she asked why to create unnecessary unpleasant situation.
My lord.
Do it. It is only to why I am saying is you can convey that to your client so that he will good sense will prevail and say that finish it up. That's the idea. Yes.
112. It is a proceeding under the domestic violence.
Yes.
So parties are the family court. The dispute is pending for divorce.
Yes.
So petitioner is ready and willing to settlement subject to permanent alimony. But when it was referred to the mediation center,
I sent to mediation.
Mediation failed. Failed because they are saying that they will settle the dispute after depositing the amount. It will be fixed by the family judge. So evidence part is already over in family judge.
I'll simply adjourn.
Simply adjourn. So after
there is their matter. First of all, this case is not maintainable. Suppression of fact matter.
No, that I'll listen to all these things. But you tell me whether there is a settlement or not.
No,
is there a chance of settlement? He says that the money, once money is paid, it will be settled.
But CP 142 by 19. What is yet to be finalized? And the Kali date अछि. Evidence sorry. So at least 15 days after it will be adjourned. Because I
put after 2 weeks.
After.
What do you say?
No inspection.
I'm just simply urging. I'm not saying anything. I'm simply urging after 2 weeks. He says that it will be settled. It is a family dispute after all.
It cannot be settled because I have filed a petition because sannyasi and on my petition.
What kind of sannyasi you are litigating in the court? सन्यासी को litigation तो कर लेना था ना सन्यासी जान तो आप you are the husband
सी फाइल करथिला डाइवोर्स सुट ताक तरफ आगे तापरे मु कली ता से न आसिला मु कली सो एटा 142:19
you are the husband then no?
I am the husband she the wife
you have become sannyasi still you are litigating.
Since I was tortured, I was forced to
do everything you left that way. That is why you left the world and went to become sannyasi.
Since I was tortured, then I was forced to take sannyasi matter.
What kind of sannyasi you are litigating?
This challenge has been filed suppressing the fact matter. Earlier approach, petitioner earlier approach and.
Consolation because of the failure. Said I'm Ohilu. CP case is CP pending in the family judge. So parties are agreed to settle this subject to the amount that is fixed by the lawyer.
How much you can give?
But Kali decide how. Evidence part sorry galan. Jahabi habo either decree.
Are you proposing something? Are you proposing something? Just very urgent matter. Upload code. Yes. See, do one thing. You ask your client, propose some amount. And I'll ask him and take the money and finish it up.
Yes.
Friday. Friday. Yes.
140. I'll say entry order tak.
Entry order to continue.
Not continue. Obliged.
13 कौन है? 14.
14.
May I be permitted to appear through virtual mode, Your Lordship? In the present case, the petitioner challenged the order of cognizance dated 9/9/2022.
9/9?
9/9/2022, Your Lordship.
Yes.
My specific limited prayer before
Charge has been framed.
no, Your
Trial
Lordship.
must be going on now.
So far, my instruction goes, Your Lordship, no charge has been framed.
Charge has not been framed. Yes, Mr. Mishra.
Okay.
Charge has not been framed.
That he is here submitting whether charge was framed or
Let's
not.
see, the cognizance was taken in 2022.
9/9/2022.
September 9, 2020.
Must have been, charge must have been.
By now, much.
Must have been taken. And madam, this is the 307 is there. Therefore, he is praying for passing the 307. Injury is there, eyewitnesses are there.
Your Lordship, with regard to the injury is
Cutlery was also seized. That offense of weapon of offense, my lord, cutlery was also seized.
Your Lordship,
What is the
however,
sound of quashing, madam?
Your Lordship, only specific prayer is that Your Lordship, under section 307 may kindly be quashed. The section 307 may kindly be dropped.
So see, cognizance is taken. You have to argue those things at the stage of framing of charges.
Lordship,
Whether a
present
particular offense is made out or particular offense is not made out, the charge court will look into. How can the cognizance order be quashed? That's the settled position. You withdraw it to raise all the point at the appropriate stage. Let a counsel for the petitioner is agreed by the order dated 9/9/2022, passed by learned STGM Nilgiri in connection to CT case number 304/2022, whereby the court below has taken cognizance of offences under section 341/323/307/34 IPC against the petitioner. The petitioner has only grievance in the present petition that from the material available on record, no offense under 307 IPC is made out. This court at the stage of cognizance is not inclined to enter into this enter into the merits of the case to decide whether the offense under section 307 IPC is made out or not. Rather, leave it open to the petitioner to argue all these points before the trial court at appropriate stage. With this liberty, the petitioner is disposed of. Next. Yes.
115.
Okay, on the request, case of counsel for the petitioner, urgent. 2 weeks there, please.
116.
Service affected. Just take it up for.
Madam, here the actual dispute is regarding to custody of the child. And opposite party has sent a letter to our office, madam. That your lordship may look into
What's
that
he
stuff.
saying?
Well, I have marked in para 6 and 7.
No, challenge is for what? FIR question.
He is saying for FIR question. Actual dispute
What
is
he
relating
saying?
to custody of that child, madam. That is my lord. That the order.
Family court?
On the ground of compromise. Page number 12, paragraph last paragraph. The direction will move to the purpose of the second or fourth of the content, madam. Allow to see. But the opposite panel did not allow to.
Visitation right.
My lord, kindly see that.
Now, what is this petition then?
He is challenging the quashing of FIR.
That can't be, because he is not allowing visitation right. So therefore you quash the FIR. All these things you have other remedy, sir. It can't be quashed because he is not complying one of the order passed in some other proceeding.
So whether the FIR will be quashed on that ground.
That can't be a ground for quashing the FIR. That can't be. What's he saying?
My lord, that.
And you people keep fighting, and this life of the child will be spoiled. Ego, only ego.
Para 6 and 7, my lord.
See, what have you done? You went to the child's school, you threatened the principal, say that I'll take it. And the principal says that, no, you are not the guardian nominated, so we will not allow the child. You have to have some limit. Merely because a civil court has allowed you for visitation right, and she is not allowing, all these things can't be a ground for quashing. Service is complete.
Yes, sir.
Huh? Appeared. Who is appearing? Yes.
One Ramesh Kumar sir.
Ramesh Kumar sir.
नहीं 116 ने appear करना है बोले.
हाँ?
कि appear करना है. One is my lord, only directly he has sent a letter to our office.
नहीं, service opposite part too. The Mokaladam has been filed.
It was not reflected in the cause list, my lord.
Monday, Tuesday. I'll send it to mediation, you settle the dispute. Or I am not going to quash it like this. But giving an opportunity, they settle the dispute. We see the child must be a very small child. And you people are bitterly fighting unnecessarily. What is the age of the child? 5 years. These people are crossing on. Tell your client that either he has to settle or he has to face the proceeding. Monday. Name of who the opposite party lawyer to reflect. And see who is appearing. You please tell him. The lawyer. Yes.
119.
What is this? Revision. Final hearing. Final hearing. Final hearing. Now all final hearing matters. Huh? Weekly. So weekly we'll see. Okay. 120.
7 lakhs is the check amount. I have persuaded my client and convinced him to pay. Only factor is time. For 6 months.
Who is appearing? Yes, sir.
I am 8,50,000 ହେଇଛି 8,50,000 ମିଶିକି ହେଇଛି 7 ଲକ୍ଷ ନେଇଥିଲେ ଆଜ୍ଞା 10 ମସିହାରେ
ଠିକ ଅଛି 8 ଲକ୍ଷ ଆପଣ କ୍ଲାଏଣ୍ଟ କଣ କହୁଛନ୍ତି
ମୋ କ୍ଲାଏଣ୍ଟ କଣ୍ଟାକ୍ଟ ହେଇନି ସେ ଦବେ କି ନାହିଁ ବୋଲି କିଛି କହିନାହାନ୍ତି ନା ତେଣୁ ଆମେ ଜାଣିବା କେବେ ଦେବେ ମୁଁ କଣ୍ଟାକ୍ଟ କରିବି ମୋ କ୍ଲାଏଣ୍ଟ ସାଙ୍ଗରେ 6 months time 6 months ନଉନୁ but 10 ମସିହାରେ ମିଳିଲାଣି otherwise
6 months I'll give with interest you pay.
With interest 15% if it is calculated, then it comes to 8,05,000.
No. From today again you pay interest and 6 months you take. See, you have taken the money, used the money.
There is no other way out for me. Therefore, I am convinced.
You do one thing. Tell your client to bring 2 lakh rupees draft on Monday.
Yes, sir. 1 month.
Give
1 month.
No. First demonstrate your bona fide by bringing some draft. Then only I'll enter it.
I bow down your lordship. Because I am convinced.
I'll put it after 1 week. 4 weeks. I am not indicating anything, sir. How much you just gave a idea. Get some money. Show him some color. Show me the color, then you come with a draft, whatever draft.
After 2 weeks.
After 2 weeks.
After 2 weeks.
Then counsel for the petitioner submits that the parties are likely to settle the dispute, therefore he seeks an adjournment. And this court will interfere in this matter if the petitioner would show bona fide by on the next date of hearing. I'm not saying petitioner. Bona fide by next date of hearing.
After 2
By paying a certain amount. I will not say the amount.
Your lordship put it after 2 weeks after.
Let him come with some draft, you take and we'll see. ଆପଣ draft ଧରିକି ଆସନ୍ତୁ କେତେ କିଛି କୁହନ୍ତୁ ଭैया ନହେଲେ କୋର୍ଟ ଏଣ୍ଟରଫିୟର if I'll dismiss it and
I know your lordship view, therefore I told him in advance.
he may be having some financial problem, but something.
Family to maintain,
He can also convince his client if there is a draft. He will tell the draft and say that she started paying, you please accept it. Bona fide देखले, he will also be in a position to convince. Otherwise, it has to be dismissed. Concurrent finding in a one-sided matter. What? Yes.
I may be pardoned. 39 of your lordship's list today. I am filing my wakalatnama. The problem being the earlier counsel, he's no more. And in the event, the appellant is also present. And I'm filing the wakalatnama so that the difficulty of no objection being obtained from the earlier counsel, that noting will not be any more sufficient. It's a vigilance case, appeal.
But I will accept it, but next time when you come, don't chew chewing gum.
I'm sorry, Milord.
In the court.
Sorry, Milord. Yes.
Give it, no.
Milord, may I pray that paper book may also be directed so that it can.
Yes.
39, Milord. CRLA 373 of 2006.
Supply. Mr. Ponda appearance on behalf of the petitioner. We see where to supply the copy of the paperwork to you. And his name will also reflect. Shall I write that you will not have chewing gum?
No, Milord, sir. Very much apologetic, Milord. It just kept my.
So that will be there. It will have a binding effect.
No, Milord.
If you have this, and the other court can also tell you. Yes. Yes.
But I may be apologetic.
It's all right. Sometimes you are sitting outside, this happens. At least you come with chewing gum. He comes with pan.
now it is not there.
In here in the Cuttack it is allowed. And in the Allahabad also you will see the lawyers are chewing pan and everything.
Song in Hindi. Pan khai saiya hamara.
Same thing there.
In fact, my learned senior was also.
That came from Allahabad itself.
Allahabad and Lucknow also.
The writer is from Lucknow.
But the chewing gum is the London style. No, Indian style.
That was with me. Now he has changed the style.
Yes.
That was with me.
I'm mentioning something.
So that hearing matter which practically the lordship had heard it. Only that exhibit 10 they had to answer the vigilance. That whether this case was given to.
It is there.
Yes.
I'll hear it tomorrow. Oh.
See, 20 108 na?